Nonsense. This order in RP. The review petition is allowed. Judgment dated 16/11/2022 in commercial appeal shall stand reviewed. Judgment and decree of the commercial court is confirmed with the modification with regard to time for vacating the premises. Amounts found due as per the judgment and decree of the commercial court shall be payable by the bank. GST, if any payable, shall be collected and paid in accordance with law without including the same in the amounts decreed.
My lord, this matter was reserved for judgment, my lord. This matter was reserved for judgment, my lord. Now I have filed IA for direction, my lord. I want to settle the matter, my lord. I don't want to litigate further, my lord. It may be kindly taken up tomorrow, my lord.
Just reserved for judgment.
I'm not withdrawing, but I want direction. I want to settle my side of share of claim, my lord. It was reserved for
After
judgment.
reserve, after being. Which is the matter?
Company appeal.
Who is it reserved by?
Last Thursday.
Something which has been reserved by you. He's saying he wants to settle. You said that we will we listed for to be spoken to. See what he says. Listed for to be spoken to. Let's see what he says. How can he settle without the other party agree? How can you settle a matter without the other party agreeing?
Please, ma'am.
How can you settle a matter without the other party agreeing?
No, my lord. In this, my lord.
Draw your appeal at best.
No, I am the respondent in this, my lord.
How can you, exactly what we are saying, how can you settle it without, after having argued the matter, how can you seek to settle it without the appellant agreeing?
Kindly, it may be postponed. My senior will convince me, my lord.
When you're seeking a listing of a matter that has been heard and reserved for judgment, counsel, you should be clear as to what you're seeking. What exactly do you want to do? You are the respondent.
Yeah, I have borrowed money, my lord, in this, but there was a
Settling the entire money.
my share. I want to settle, my lord, because she is a widower.
You should have done that when the matter was being heard.
I got instruction day before yesterday, my lord, regarding that.
To be spoken to.
My lords.
We seriously doubt whether this can be done. We list it for to be spoken to. If it is not acceptable, your request will have to be rejected. Anyway, list it for to be spoken to. Yes.
It's a pending matter, my lords. Previously, your lordship has directed to deposit certain amounts. Now the appellants has been without depositing the money. Now they have filed an application for modification of the order, my lords. A kindly matter may be taken for day after tomorrow, my lords. Please, oblige.
I apologize, my lord. One more memo. My lord, it's a final hearing matter, my lord. 2022. There's a 2022 matter, my lord. RFA may be taken on any day in the next week, my lord.
2022 matter, we are afraid, cannot be taken up for final hearing.
Final hearing.
This one, page 1, number 2, page 2, number 3 to 5, page 3, text, page 4, the comment, page 5, the 8 to 12, page 6, the 13 to 19, page 7, 20 to 22, page 8, number 22 to 26, page 9, 27 and 28, page 10, 29 and 32, page 11, number 33 to 37, page 12, number 38 to 41, page 13, number 42 to 44, page 14, number 45 to 50, page 16, 61 to 5, correcting 68 and 69. Page 18, 60 and 61. Page 19, 67.
Serial number 64, my lords. I'm for the appellant. Short accommodation may be granted, my lords.
Have you informed the other side?
My lords, I am for the respondent.
Yes.
Kindly have it on the 25th, my lords.
It's on. Yes, at the request of the learned counsel for the appeal, list out.
Serial number 12. Serial number
68. I seek for 4 weeks time to file a paper book.
Have you informed the other side?
Yeah. His colleague I informed.
Yes, learned
Lord,
counsel for the
69.
appeal seeks time.
Commercial appeal, I appear for the respondent, seeking a week's time.
From the other
69.
side?
Appearing on behalf of the appellants, my lords, in 69.
Yes. At the request of the learned counsel for the respondent, list out.
My lord, serial number 70,
16.
my lord, serial number 70, kindly adjourn the matter for 2 weeks.
Who do you
Appearing-
appear for?
Appellant.
Is there any appearance on the other side?
No, my lord.
Yes.
Kindly register, my lord. Serial number pertains to 56, my lord. In connected appeal, we are 56. 56, my lord. The matter pertains to land acquisition. My lords, we are in the connected appeal. We have filed one application regarding the additional grounds and additional pair. That has to be listed before final hearing. My lord. In the connected petition, my lord.
Please be here.
Yes, my lord.
Yes.
That has to be heard before, my lord.
Yes.
Serial number 12, my lord. 1 week time. Senior is not feeling well, ma'am.
Please be here. Please mention when the matter is taken up.
List 2, order, Silverman, Adjournment.
For the petitioner, my lord.
For the respondent.
Partition suit.
Lord, I have to
partly
file the
decreed.
objections in this matter.
Habeas corpus.
Oh, I'm sorry.
I was supposed to file the objections, my lord.
Sorry. Just a moment. Yes, the US citizen.
Yes,
my lord.
Yes, objections are filed. You're ready?
I could not file it in the registry, my lord, if I can.
Yes, shall we pass this over and hear it?
Yes,
I'm ready to argue right now, my lord.
Pass over. Just rush through the list and come back to you.
My apologies, sir. File memo for posting, my lords. We are withdrawing the petition. It may be taken up on Wednesday, my lords.
Yes, this is the matter where partition suit has been partly decreed.
Because
Yes.
this was heard for some time for the other court, not then it's now for your lordships. I think the lower court records, not unfortunately, is not come. Would your lordship also direct that to be brought up, my lord, because there are
May have
about
to be
15.
here.
The entire paper
may
books
have
have
to-
been filed. I
We
think
filed
lower
paper
courts
books,
records
but
may
there
not
are
be.
some documents which are missing in the paper books, which I noticed, which we are also not able to get.
Okay.
Call for the TCR. Yes. Yes, so and so appears for the respondents. Admit, call for the TCR, list on a date.
July,
Kind of.
July sometime.
Yes.
Okay.
It is it.
Appear for the respondent. I am filing a list of citations and relevant documents. Permitted to file.
Rate of interest, that is the only question.
Yes, please.
Rate of interest is the only question.
True, but there is no award at all that is can be amended. That is my.
Sorry?
There is no award in law that can be corrected. Therefore, I am citing the citations. I am given the copy to my friend. May I pass on this?
Ready in the matter?
Yes, please.
Can we pass over and hear it?
Yes, please.
May I pass on the citation? Please. ಕೊಟ್ಬಿಡ್ತಿದ್ದಲ್ಲ. ಆಯ್ತು.
I appear for the petition in the matter, my lord.
Hmm.
Ready with the matter, my lord. Me passed over.
Ex parte award.
Ex parte award, my lord. Lower court has.
34 dismissed as belated.
Yes, my lord.
Notice served on 38/2013.
My lord,
Copy of award served on 9/11/2013.
it is not served, my lord. What is my stand is that I was never served with a copy of arbitral award. It's only after the execution petition was filed that I was aware of the arbitral proceeding. In fact,
Finding that it was served on 9/11.
the
What was, am I
not
right?
not the award, my lord. The arbitral proceedings, my lord. So initially, it is the case of the respondent that they had filed the arbitral claim before the arbitrate in Chennai, but issued a notice for arbitration.
Notice of arbitration.
Notice
the
for arbitration.
Section 34 order says that notice of arbitration was served on you on 38/2013 and that the award was served on you on 9/11/2013.
I have
I filed
disputed
the
that.
objections, acknowledgements also, along with the objections, Your Lordship.
No, my lord.
We'll hear it.
We'll hear it,
Pass
my
over.
lord. Pass it, my lord.
Respond number 1 and 2, kindly pass on.
Pass on.
These are not first appeals filed from judgments and decrees.
Interest is the question.
Interest, my lord, the only contest, my lord, is this. We made payments periodically. They say that I am entitled to interest on the delayed payment, so I'm appropriating it towards interest. Though there is no contract regarding interest. That's the only point not to be heard.
This matter was
Can we hear this
for
today?
some time earlier, and the court suggested that you deposit some amount, whatever admitted amount, then we will grant stay.
We can
So
hear
if
it
they are
today.
interested in,
We
deposit-
can hear it today, Counsel. Are you ready?
Tomorrow I'll argue. Tomorrow, if that is.
Please.
Yes. Learned Counsel for the
They have
respondent.
admitted to the extent
Seeks
of
a
4
day's
crores.
time list. No, let's not worry about all that. Matter can be heard. The question is simple. The question is only whether interest as ordered is correct or not.
Yes.
That's the only question. Yes,
If Lordship
tomorrow.
permits, my lord, I may begin today. My learned friend can do it tomorrow, my lord, if it is convenient.
There are some matters which have
Very
been
well,
passed
please.
over.
Then
here.
I'll take chance.
We'll have it tomorrow.
Please.
The appellant, my lord. Unless we've issued NOC in the matter, my lord. Our name may be deleted, my lord.
Learned Counsel for the appellant seeks time. List after 2 or 3 weeks time. Money.
Right, madam. I seek lot of a little adjournment next week.
Earlier, my lord, 6 lakhs were directed to deposit. Subsequently, I moved without serving notice from the respondent. The amount is reduced, my lord. 2 lakhs deposited. Till today, they have not deposited.
Even the 2 lakhs is not deposited.
Not
2
deposited.
lakh, 2 lakhs deposited, my lord.
When?
26th.
Where is
26.
the- where is the record? They have to serve on the, obtain the respondent. That is the,
ನಿಮ್ದು ಇದಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ನಿಮ್ಮ ವಕಾಲತ್ತು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಹಾಕಿದೆ ನೋಡಿ ಸರ್ ನಿಮ್ಮ ವಕಾಲತ್ತು ರಿಜೆಕ್ಟ್ ವಿತೌಟ್ ಸರ್ವಿಂಗ್ ದಿ ವಿತೌಟ್ ಅಡ್ಮಿಟಿಂಗ್ ದಿ ಮ್ಯಾಟರ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್
but the list has to be. There is
ಆಗ್ತಿದೆ ಇಷ್ಟೇನು ಆಗ್ತಾ ಇದೆ
Where has it been deposited?
22nd.
Where? 22/5. So and so. 26/5.
My lord, judgment amount is 16 lakhs. There is a lapse at the dependent.
11 lakhs with interest.
Ah,
11 lakhs with 12% interest.
12%. The 16 lakhs, my lord. 16 lakhs with 12% interest. More than 20 lakhs.
It's not 16 lakhs. Is it not
16
11?
lakhs, the decree amount is 16 lakhs. my lord.
Decree amount is
6% interest.
decree amount is 11 lakh, madam, excluding interest. Excluding interest.
Interest at 12%.
12%.
Yes.
Yes. I have only payable 1,59,000 only, my lord.
My lord, since 2019, yes, he is struggling. But wait, my lord. At least only 6 lakhs may be directed to deposit, my lord.
No, no, no. I have payable only 1,59,000.
Is there any chance of a settlement between the parties?
Please,
Is there any chance? Please tell us whether there is a chance of settlement between the parties. It can be
next week.
referred to mediation. It's all. Please don't say that only to dodge.
I will contact my client, my lord. I will contact.
Next week, my lord.
Yes,
Yes.
learned counsel for the appellant submits that some time may be granted to verify whether there is any chance of settlement between the parties. List next week.
Please.
Give a date, please.
Please. But this matter was heard for a little while and your lordship has made an interim arrangement. May have to be heard. Any date your lordship may sign.
Otherwise, ready? Are the records necessary?
Records may be necessary. Records may kindly be called for.
Admit, call for the records. List.
Now they've been called for.
Admit, call for the records and list on. Yes, immediately after records are received.
Great.
Petitioner in this case, my lord.
I appear for the respondent, my lord.
Sir, I have filed a memo along with NCLT copy, my lord. Already petitioner company is already winding up, my lord.
Settlement attempted, no written statement decreed as prayed. Yes. No,
I'm already paid the principal amount, my lord. Respondent, if any interest, we approach before the NCLT court.
In fact, if I make a humble submission, my lord, I appear for the respondent. The suit was filed by the respondent before the Honorable Commercial Court. It was in the favor of the respondent. At the stage of the appeal, the appellant had made a humble submission before my lords, stating that they will make a deposit of the interest amount at the rate of 18% much prior to the order passed by the Honorable NCLT, my lords.
Yes, what can be done at this stage? What is the date of the order? 26/3.
My lord, 8/4/2025, my lord.
And the order passed by my lords
2025
has been much prior to that, my lords. In fact, it is an undertaking taken by the appellant itself. Initially, under the invoices, my lord, it was 34% as the interest rate. Under the invoices, my lords.
34%.
34%. That was the mutually agreeable interest, my lords. But upon an appeal being filed before my lords, the appellant had agreed to pay 18% interest on the amount, my lords.
When is this? 3/3/25.
Please, my lords. Much earlier to the order passed by the NCLT, my lords.
$46 lakhs paid.
Please, ma'am.
47.
Further amount of 1,52,000 is still due and payable. That is towards the principal.
Please, ma'am. Apart from that, at interest rate at 18%, my lords.
Moratorium was declared. Once the moratorium is declared, this also will apply rates. Yes, it is submitted by the learned counsel for the appellant that an order has been passed by the National Company Law Tribunal, Bengaluru bench, on 26/3/2025 under Section 9 of the IBC 2016. List after 4 weeks
Please, my
Let
lord.
us see what happens in the meanwhile.
At the same time, I may be permitted to file any objections if so, my lords.
Objections,
Please.
if any,
Much obliged.
filed by the respondents. Yes,
In fact, that do not cover, but just in case, my lords. Please.
let us see.
Much obliged. A date may be fixed, my lords. Please, much obliged.
Eviction and arrears.
Respondent, my lord, proxy counsel for the respondent counsel, my lord. There's an appeal filed by the respondent also, my lord. It may be taken up along with for.
There's another appeal filed.
Please, my lord.
Yes, list along with, that is also commercial appeal.
Appeal
Yes.
147 of 2025. Taken up together.
Yes.
The interim order be extended.
List after 2 weeks, the interim order shall remain in force till then. The rate of rent itself is in dispute.
Rents are paid, only the range of the rents. that's
Rate
all.
is
Yes,
disputed. Yes,
I appear for the appellant, my lord. 1 week time, my lord. Senior is not feeling well.
appeal for the respondent.
yes, 23/6/2014, agreement for sale.
Registered agreement.
Defense is that it was a mortgage.
Yeah, it's the defense. But file the return statement, but its matter has been posted for evidence, they have not appeared. Court has given an
Week time, my
opportunity
lord.
and finally
Senior
court
is
has
not
decreed.
feeling well.
Sorry?
1 week time, my lord. Senior is not feeling well.
Learned counsel for the appellant seeks a week's time on the ground that the arguing counsel is indisposed. This next week, give a date.
Please.
Here for the initially my dispute that had been filed was seeking the relief of partition in separate case.
It's partly decreed.
Partly declaration is granted. Now 3 items of the properties are there. 1 and 2, my lord, I have gifted in favor of my grandson, who is none other than the son of the respondent, who is none other than my daughter. Now item number 3 is an agricultural property. My lord, a bill is being set up. No attesting witnesses, my lord, are examined in support of the said contention.
The scribe is examined.
Scribe is examined, but scribe will never take, my lord.
What happened to the attesting witnesses?
They do not say that. Nothing.
That
my
they are
lord,
not
is
alive.
spelled out. Now, scribe witness, my lord, evidence will never take, my lord, the character, my lord, the requirement of section 68. Now, this is, my lord, decree. Only declaration is granted. There is no consequential relief that is even sought. So, the suit, my lord, itself is incompetent as per section 34 of this procedural act. Wherein, my lord, a person doesn't seek any consequential relief, my lord, then the declaratory relief cannot be granted. Now, my lord, I am the mother and this is the only, my lord, land that is available for me. The other properties has been gifted in favor of my son. Now, after the decree is granted, my lord, she has got the khata changed to her. And now she has made an application for converting the user of the land to non-agricultural purpose. All, my lord, the coconut gardens. But for my livelihood, my lord, this is the
What is the extent of the property? Schedule
acres, my
3.
lord, is the extent of land. Hence, my lord, I am seeking stay of this order so that, my lord, let there not be any change in the nature of the property pending there.
What do you
Under
say?
the item 1 and 2 as acquired by the defendant number 1 under through will. And
Sorry?
under through will, item 1 and 2 properties are acquired by the defendant number 1. In the same will, the respondent also acquired the will. Will is acted upon. As per the will, I filed a suit for declaration of the relief in respect to item 3 of the property. The court has found that already item 1 and 2 has succeeded under the will. She has sold the property and gifted the property to the respondent number 1 under
She's
the.
not sold the property. She's gifted it to
gifted-
your son.
Gifted to my son.
Hmm.
Then the will is acted upon. And under the same will, I also acquired the right over the property item 3 of the property. Therefore, the suit has decreed by the trial court. As per the, she has already acquired the property under the will and she has gifted to my son. And will is acted upon as per that. And after that, I filed an application before the authorities and I got a revenue entries in my name.
What happened to the attesting witnesses?
The attending witness, the examined as one scribe of the witness is concerned.
No, what happened to the attesting witnesses? Are they not alive? Do you have a contention that they're not there?
I have to verify that.
The only question is that.
Examined only the attesting The scribe
Only
of the
the scribe.
document, yes, the scribe of the document is executed.
You can do that if the attesting witnesses are not available. You say anywhere that the attesting
I
witnesses are
understand.
not available when you're setting up the will in respect of this property. You only want to know whether the attesting witnesses are there or not.
I have to verify.
That is, even if it is not disputed, it has to be proved
The
in the
will
manner.
is not disputed, the will is.
Even if it is
admitted
not
the will.
disputed, does it
There
not-
also- There also get right over the property handed through will. I also get a right over the property handed through will.
We agree. Still,
Yes,
how is a will to be proved?
by
You are perfectly aware. We are just asking you whether the attesting witnesses are available.
yes, I'll verify that.
Yes. In the meanwhile, you are doing nothing with the property.
Revenue entries are already transferred in my name under the
Application for
under the
conversion
decree.
of the user of the land has been given. Let there not be any conversion of the user of the land. It's an agricultural property. Let it remain so.
For that is concerned.
Now to my lord, make a site of it and sell it and create third parties, my lord. Okay, yes.
I acquire the property and it will have right over the property.
Which is why
She has
there,
also acquired the property and item 1
There
and
is
2
a-
under through
we
will.
are in a first
When I
appeal.
am not objected, the item 1 and 2 is concerned. When she has got.
it is to your son that it has been.
When she has got a right over the property and she has put an application.
How
before
old
the
are you?
authorities,
How old are you?
34 years.
That is all. How old is the son?
Son is 11 years.
Okay. Mm.
Under the will also she has got a.
Yes.
Under the will also she has got a revenue document, item 1 and 2 is concerned. And the same document I also acquired the buyer, get a right over the properties and will. When I am not objected, when she is getting the right over the property and as for the revenue entry is concerned.
Hmm. Is there any chance of settlement?
Lord, she
Mother
must
and
take care
daughter.
of me. I'm the mother. I'm 59 years old,
She has,
specially abled. My lord,
No, she has
some
employees.
difficulty is there. I'm a government teacher.
Now,
I'll retire in a year. Now somebody must take care of me. All properties are gone now by the virtue of this judgment. Lord, what do I do?
Only one
Your own-
property. Another
That is
two
your
parties.
own doing. You,
Ultimately, my lord, it's his daughter and the grandson, my lord. Obviously, my lord, the love and
obviously
affection is something that.
obviously to keep the daughter away from the.
Yes, yes.
My lord, that could even go to the daughter. There is no difficulty in that.
Yes, we'll,
Please tell us whether there is any chance of a
I will,
settlement. in the
will
matter.
contact my parties.
Yes.
After next week, we'll report it.
The
If
parties in
possible,
this
we'll report.
appeal are mother and daughter.
Yes, madam.
The learned counsel submit that chance of settlement, if any, can be explored in the matter. List next week. Let us see.
Let there not be any precipitation. That's what I am requesting. Now, application for conversion is
Next
given.
week, nothing
In
will
this
happen.
1 week, nothing is going to happen.
Yes.
No, they
Let
are-
us have it next
no,
week.
They
Let's
did
see.
the khata change, my lord, after the judgment was done.
Of course, Khata.
Now,
Yes.
the next
Yes.
step that they are taking is this.
Next week, please tell us whether there is a chance of settlement. Here again, partly decreed.
I appear for the respondents.
May it please, Your Worship.
Title to temple property. Title to temple.
Temple property partly decreed, and there was an order of injunction given by the Supreme Court itself. Based on that, on an earlier occasion, it was the records are called for, and if this interim order is continued, maybe they will file the appeal or not. We do not know.
Lord, insofar as IA number 1 and 2 is concerned, Lord, orders have been passed by this Honorable Court on 15/5/2025. Lord. I would like to file objections. Now, the IA number 2 is with regard to the stay of one particular paragraph in the judgment. That is with regard to an inquiry with regard to misconduct by the plaintiff number 2. Now, this is a suit for declaration, Lord. The plaintiff, the temple was plaintiff number 1 and plaintiff number 2 is the individual person.
The declaration with regard to title has been granted.
In favor of the temple, my lord. Now, this is a notified institution under the
Yes.
Mujrai department. my
Yes.
lord. Now, the question is whether he can continue to be in possession of the temple property itself. Now, he has failed. The earlier judgments of the Honorable Supreme Court in this matter itself, my lord, is prior to the passing of the judgment. The trial court has come to conclusion that the temple is the owner and deity becomes the owner of the property and the temple, my lord. Now, insofar as P2 is concerned, my lord, he is only an archak who performs puja, my lord. Now, the trial court in para 68, my lord, that has also been culled out in IA number 2, IA number 1, my lord, where Lordship may kindly take page 113, my lord. Page 113, my lord. Or para 68 of the judgment itself may be referred, my lord. That's that page. Lordship will find it at page 99, my lord.
Yes.
Issue number 12, my lord. Both first plaintiff temple and its property are in possession of the second plaintiff. As a matter of fact, he is having a right only to manage the affairs of the temple and to take care of its property. In case any gross mismanagement is noticed by Mujrai officer, he is empowered to initiate an inquiry, and if mismanagement is proved, he can take possession of the temple and its property to his possession and control as per the law. When such being the legal position, suppose a relief of permanent injunction is granted, restraining the defendants from interfering with possession of the second plaintiff, obviously it will be against the spirit of the Mysore Religious and Charitable Institution Act 1927. More so in this case, second plaintiff has not at all established that there is any kind of interference to his possession. Now, my lord, by virtue of this IA, my lord, and the interim order passed by this honorable court, there is a stay with regard to the inquiry. Now, this is a statutory inquiry, my lord, which can
Had
be...
you initiated the inquiry?
No, my lord. Now, by virtue of the interim order, I'll
There
file
are-
my...
There are certain grounds on which an inquiry under the charitable.
Yes, there are complaints by the public, my lord, with regard to mismanagement.
Yes.
I want to undertake that inquiry. Now, by virtue of the interim order passed by this honorable court, I'll be prevented from holding any inquiry.
Now, where is the
That's-
material to show that you have initiated any inquiry or there is material to initiate an inquiry? It
I'll
is
place
only-
that on,
it's
along
only
with my
if-
objections, my lord.
Only
Ma-
factually all those are
Yes,
there.
I will place it on record.
Please do. The,
May I request for 10 days time, my lord, to file objections to both the IAs?
Learned counsel for the respondent seeks time to place objections to the IAs. List after 10 days.
Yes.
Interim order mechanism.
Interim order shall continue in force.
Grateful mercy.
20.
Appellant, your lordship.
Yes. 2 acre 36 guntas.
Yes, your lordship. It's a suit for
And dated
performance.
12/1/2004. Agreed.
Yes, your lordship. In this matter, it is a partnership firm which is the agreement holder. The partner has not signed the agreement. She has signed the plaint, and thereafter eminent plaint is signed by her husband. And those material particulars are not taken into consideration.
Awaiting TCR.
Await LCR.
Let the TCR come, please.
The interim order granted by this honorable court has to be extended, your lordship.
Await TCR. Just after TCR is received, interim order shall remain in force till next date of hearing.
I will to appear for the respondent number 4 in this matter. Oversight on the part of the registry, my name was not shown. Could not take note of the listing. I could get instructions from the client only that the matter is listed today in the morning. This is the 4th round of litigation. In relation to a very short question of law.
24 feet passage.
Please, that is a public road. There is a government notification declaring that the extent of passage is a public road. What, the appellant would do is, for the construction of an apartment, they would seek, amalgamation of the khata of their private properties with the public road. My lords, I would, my lords, challenge the amalgamation of Khata that was passed with the BBMP, my lords, before this honorable court. This honorable court, my lords, would relegate me, my lords, to the BBMP authorities, saying that there is a provision under the KMC Act, file an application for an inquiry. My lords, an application was filed before the BBMP authorities for initiation of an inquiry. There, my lords, the BBMP authority, the additional committee.
Requesting for a password. Told my lord that they have engaged a senior counsel. He's on.
Sorry?
He's on the other court. A senior counsel is engaged. It may kindly be passed or my lord, they'll come.
May I request, my lords, anytime during this week, my lords, subject to my lord's convenience, because this is the fourth round of litigation.
Can we have it next week?
Very well, subject to my lord's convenience.
Yes, counsel for the appellant seeks a short accommodation. List.
My name may kindly be shown, my lords, for
Show
response.
the name of the learned counsel appearing for R1 to 3.
R4, my lord.
1, 2, 3, I am appearing.
The state is up.
Yes, R4.
Great.
I'm so very grateful.
Madam, may kindly wait.
I'm sorry. Remain in place till next date of hearing. Item 17. Requirement of a scheme
Please,
found against. The Supreme Court says there
it's
is
not
no
necessary.
requirement.
Your lordship, my lord, disposed of, my lord, many cases relying on, my lord, following.
That's the
That's the
only
only
ground.
ground.
Let it be listed along with other matters.
Not
Other-
necessary.
No other matter. Here, your only contention is that there is no scheme and therefore the notification is bad.
No, other grounds are there.
What are the other grounds, please?
Notice
Okay.
The grounds in the writ petition are issuance of preliminary final notification is illegal both on facts and law. Section 17 enables board to incur expenditure, undertake work. Scheme is provided.
Deleted other lands. Survey number 21/1, 4 acres is deleted. 3 acres 12 guntas is deleted.
No housing scheme
47 is
available.
deleted. Other grounds are there.
Petitioner will be deprived of his livelihood.
Other,
Issued
same grounds
otherwise
are
opposed to law and facts. Authorities have acquired vast
annexed.
land for formation.
Ground I.
Petitioner states in all
Ground I.
ground.
The authorities have deleted 3 acres 12 guntas in survey number 14.
That is not a
bar one.
ground. That is not a sustainable ground.
Same grounds are raised in the other matters also.
No notice of acquisition, hence acquisition is bad.
Series of matters are there.
Series of matters are there. It is listed at serial number 18. Other matters are there.
There are other matters, counsel, but there are absolutely no other grounds in this
Last
petition.
time I have it
This
along
is
with
one
the-
such
I-
petition
I'll
where
be
there
able
is
to-
no other ground.
I will be able to say, I have other matters also connected to that. Last time I have it that next day.
Agree that there are other matters. The
Deletion
only
and-
difficulty is that there is no other ground available in this writ petition.
No, I'll be able to point out. I have not read. I thought that it should be connected with other matters. Other matters are.
Several of these matters, your contention was that before framing a scheme under section 18, housing board cannot notify. It has been found against by the Supreme Court. There are several other matters pending. But there are some at least the namesakes or other grounds. It's not there is not there to be any other ground. Only this ground. Submit said no notice of acquisition was served, hence acquisition is bad in law. Yes.
Lord, there's no, my lord, other grounds, my lord, as my lord's may seen, my lord, now. Just, my lord, simply, my lord, keeping,
No
my lord,
notice
pending
is-
this, my lord, writ petition, my lord, writ appeal, my lord. My lord, come in the way of, my lord, the KHP, my lord, to develop the, my lord, the land. My lord, your lordship, my lord, has already, my lord, disposed of as many as, my lord, so, my lord, more than 10 or 15 matters, my lord, where, my lord, the sole ground is that, my lord, the scheme issue. My lord, this is also same, there are no other, my lord, ground.
Other grounds are there.
Court of
Including that no notice was issued.
Sorry?
No notice has been issued to the appellant. Apart from that, other lands are
They are
deleted.
aware of the merit of those contentions normally.
The last time I have.
There have objections been filed.
No, my lord, notice not at order. my
No
lord.
notice is ordered.
Still, my lord,
Notice is
says
ordered.
it's- delay the answer. Para 45 minutes.
So only for the purpose of execution that
Please.
the scheme is required.
Required.
Only other grounds are not even considered.
Not before, my lord, initiation of acquisition proceedings, my lord. What, my lord, Supreme Court, my lord.
No ground is considered. And there is a direction in the writ petition to post this matter after the WAs are disposed of.
Joint reading of the aforesaid provisions will unfold the duties of KHP as to undertake housing schemes, land and land.
No grounds are considered. Except the sanction.
Forty-three, 44 important. 44 is my lord relevant.
That should have it next week, or along with other matters.
Not along with the other matters. Please argue this on its merits.
Next week.
Please tell us whether the notice has been served also. That is the only,
Please.
only surviving ground is that.
Please.
Nothing else. That notice has not been served. Yes.
Next week.
Government advocate as well as learned counsel for the KHP seek time to get instructions in the matter. List after a week.
Please. Date.
Please give it.
19th.
For the appellant in this matter. Matter pertains to PTCL Act, my lord. The land was granted.
You are for the
Appellant, my lord.
The
And for the
appellant is-
grantee, my lord.
grantees
Please, my lord.
LRs.
Yes, my lord.
Original grant.
Grant is in 1942
Yes, my lord.
and mortgage is in 1951.
1951, my lord.
When do you make the application?
Lord, in the year
When does the act come into force?
1978, my lord.
1978.
Yes, my lord.
When do you make the application?
2010. My lord.
Okay, then please.
Mortgage deed, my lord.
This is
Simple
covered, my
mortgage.
lord. Actually, this is covered.
Yes.
And in fact,
2010, after, forget the earlier
Yes, my lord.
dates. From
Within-
1978 onwards, when you get a right to seek repatriation of the land.
that's true.
From then onwards, you do nothing till 2010.
They are claiming under mortgage deed, my lord. In the,
See?
they are respondent number 12 claiming under mortgage deed, my lord.
Claiming under?
Mortgage deed.
Ah,
Mortgage deed executed in the year 1951, my lord.
1951.
Under 1951, my lord.
Hmm. Not challenged, never challenged.
No, my lord. Under
After
the
78.
simple mortgage.
After 78, you get the right to, and beyond that, there are several sale deeds thereafter also.
Till
Please, my lord.
2000
2006, there is a sale
Till
deed.
2006, my lord.
2008, second sale deed.
Yes, my
You
lord.
do
Till
nothing.
2006, my lord, revenue records continued in the name of LRs of the appellant, my lord. In the name.
You in possession.
Yes, my lord. In the year 2006, my lord, they have made application for inheritance kata of the mortgagee, my lord.
Hmm.
They have sold LRs of the mortgagee sold in the year 2006, my lord.
Hmm.
Immediately, in turn, he has respondent number 12 has sold in favor of the one Ratnamma in the year 2007.
Hmm.
Next, Ratnamma has gifted the property in the year 2008, my lord. Immediately, within 2 years, my lord, the appellants have filed application before the Assistant Commissioner, my lord. Till 2006, revenue entries.
For the transfer occurs in 1951.
As per my instruction, my lord, they have
Not a mortgage or transfer of property.
under the simple mortgage, my lord. Can we pass over the matter?
My lord, if I may submit,
there was a writ appeal wherein this concept of delay was looked into. And that then was challenged before the Supreme Court. The Supreme Court has held not to interfere, and that holds the fort right now. If I may just submit the, okay.
Can we pass over the matter?
Pass over. Here also,
Same year.
grant in 1955.
Yes,
Sale
there's a
in
delay of
1965.
35 years over here.
447 days delay. No appearance for the appellant. No appearance for the appellant. There's no interim order?
No.
No order?
No.
Please record that there is no appearance for the appellant.
I appear for the appellant.
I appear for respondent.
I appear for time, my lords. The arguing counsel is not well, my lords.
I'll leave it
Any
to-
day after 12th, my lords.
Counsel for the appellant submits that the arguing counsel is unwell. List after. 2 weeks.
Interim order may kindly be extended.
Order shall remain in force till the next date of hearing. APMC.
Appearing for the government, my lord.
Today, my lord, we have filed one application. My lord, what has happened is, we had entered into an agreement, my lord, calling for bids for, my lord, setting up a market yard. This was, my lord, some 12, 13 years back.
What happened to the acquisition?
That never came about. So, my lord, government, by virtue of section 126A of the APMC Act, directed us saying that, look, this kind of thing can't happen. So terminate it. We have terminated. Arbitration is going on. So, my lord, we have filed one application today morning saying that till the arbitration proceedings are taken up, please adjourn this sine die. If it is needed, we'll revive it. Otherwise, my lord, there's no point in wasting a lot's time and my minutes.
I have no objection.
Is that
for
agreeable
adjournment.
to everybody?
No objection for adjournment, but one statement made in the IA for adjournment may not be strictly correct.
How that?
Because
Sorry. My lord, if
they
it is
say
so, I
that
withdraw it.
the
That's all. I
para
didn't know.
9,
Nine,
they
is it?
say, subject matter of the present appeal and the issues arising therefrom are substantially pending adjudication.
May not be, my lord,
and
but
appeal.
peripherally, my lord,
That is
it
not
has
correct.
some effect. That's all, my lord, I would say. My lord,
That is not correct.
All.
Because the issues there are totally different, but they pertain to the same contract.
That's right.
That is fine.
No. What we'll do is we'll not record the
Very well.
statements. We'll just say that we'll.
Very well.
Please.
It is submitted by the learned senior counsel appearing on either side. That an arbitration is pending between the parties.
Yes.
The matter is, the writ appeal is therefore adjourned,
Please. Yes. Great.
awaiting the result of the arbitration.
Please. Great.
Lordship's kind permission, my lord. But today, little inability to argue because my throat is not well.
That is all right. Can we condone the delay of 1
Yes,
day
my
in
lord, that
filing
is
the-
only 1 day is there.
That can be condoned. Yes. IA number 1 of 2024. Heard the learned counsel on either side. Accepting the cause shown, the delay of 1 day in filing the appeal shall stand condoned. List for admission. When do you want it?
Any day after 2 weeks, my lord.
Many times, my lord, it is adjourned, but the lordship may give next week, my lord, if
Please agree on the date. We can list it on whichever agreed date it is.
After 2 weeks, my lord, any date.
Please give a date.
please.
Office objections are complied? The learned counsel for the appellant submits that the office objections stand complied with. What is this memo dated
A
19?
memo that certified copies could not be, because could not able to obtain. For that reason, we have filed a memo saying that is not available.
Memos there. Is there any objection to that?
No, ma'am.
Yes, the memo is taken on record. Office objections on that count shall stand. Other office objections are complied. Yes, IA 1 of 2025 is therefore allowed. The order dated 23/10/2024 shall stand recalled. Issue notice in the delay petition.
Yes, ma'am.
The IA for the IA. Who do you appear for? Which respondent?
My lord, I will be appearing for respondent. 10, 9 and 10, my lord.
Learned Government Advocate takes notice for respondents 9 and 10. Appellant shall take out notice to the other respondents. In the IA. IA 2
Oh,
of
sorry,
25.
sorry.
Issue notice to the other respondents.
This hasn't been served on us, this writ appeal. Sorry. There's another.
Issue notice to the first respondent. Learned Government Advocate takes notice for respondents 2 to 4.
We haven't been served, so sorry.
Yes,
they'll serve
please serve a copy.
I'll serve the copy.
Please, much obliged.
List after service is complete.
Right.
To R1, please take it out.
Yes.
In this case,
Yes.
land acquisition matter, the
1563
claimant is seeking for
days.
enhancement.
1563 days delay.
Yes, I shall,
Counsel
Establish that.
submission with regard to extended
with regard to the other,
value of appeal deficit court fee
with regard to that, my lord,
is kept in abeyance as per order dated 29/5/20.
with regard to that, my lord,
Hmm.
actually,
That's
I am the owner for 5 acres, 16 guntas. For 22 guntas, they have not passed that, but I have paid the court fee here. I will establish before the Salama court the time.
Lord, I'm
Say, are you taking notice for the respondents in the IA?
My lord, I'm for the respondent number 2.
So you'll take notice, please, the IA
Please,
for condonation.
please.
Yes. R 1 and 3 at CGP. Shrimati Vaishali Hegde for R2. Yes. All served.
My
We'll
lord, it's already served. We are
We'll
for the-
condone the delay on condition that you're seeking enhancement.
Yes, I am seeking enhancement.
On condition that the interest will not be calculatable for this delay.
My lord,
Can it
for
be?
this, I'll take instructions, my lord, because
You're served and it's coming up for continuation, counsel. You're
I'll-
expected to have instructions today.
please,
Can be?
please.
Yes. Heard IA for continuation of delay, heard both sides. In view of the awareness in the application for continuation of delay and in view of the fact that the appellant is a land loser, the IA is allowed delay of 1563 days in filing the appeal shall stand condoned. However, no interest shall be payable on the enhanced amount, if any, for the period of 1563 days when the appeal has been filed belatedly. Will you take notice in the main also?
Please.
Yes, list it on, take notice and records have to be called for?
Not necessary, my lord.
Not necessary.
Not necessary.
That matter, my lord, from Friday, is adjourned to today. Lord, suit for
29
eviction.
days.
And my lords were had directed my lord him to.
The respondent, my lords.
Respondent is ready to settle the matter.
On the last date, my lords, the sample court directed me to ascertain whether he is willing for mediation. He is not willing, so my lords.
So shall we condone the delay then?
No,
Have you
my lords.
filed an application? I mean, objection?
We have filed the objections, my lord.
They have filed the objection. My lord,
The objection.
They have not
the
stated the
ground for
date
condemnation
itself,
of
my
delay
lords.
is, my lord, that my counsel did not appear. Their objection is, my lord, that the same counsel continue, but it is, the fact is otherwise. Initially, my lord, I was on record. Thereafter, my lord, during my lord, 23/8/2022, a new counsel has filed the wakalat, he did not appear thereafter, my lord. That is the only ground. He did not inform me.
What is the number of days of delay?
429 days.
Where is your affidavit? What have you stated as the reason?
Paragraph number 5, my lord.
Just a moment.
Paragraph number 5, my lord, of the affidavit. Magistrate, my lord.
Where is the delay petition?
Should be page 36.
Yes.
Para 3 onwards.
Mm.
I submit that initially I had engaged the services of Advocate 1 Sri H.S. Prashant. Thereafter, I took a
This is the statement
from him.
objections. Where is the delay? This does not have a.
Page 36. May I read? I submit that initially I had engaged the services of one Advocate 1 H.S. Prashant. Thereafter, I took no objection from him and engaged another advocate. And said advocate has appeared and has filed written statement in the matter. Thereafter, the court directed depositing of 50% of the arrears of rent on 28/3/2022. Plaintiff filed an application seeking for striking of the defense for non-payments of the rents. But this fact of filing of the application is also not known to me, as on 25/3/2022 and 28/3/2022, when the application was filed, as could be seen from the order sheet, my counsel was not present in the court. Thereafter, continuously, my counsel has remained absent and no cross-examination of PWs was done. Ultimately, the judgment and decree came to be passed on 19/9/2022, and even the fact of passing of the judgment and decree is also not known to me. I am not liable to pay any money to the respondent, as due to respondent's non-cooperation, I have lost money in business and reputation. I submit that in the meantime, I went to the sub-registrar office in connection with some other matter through JP Nagar sub-registrar office. I came to know that there is an order for attachment on some other property belonging to me. On verification, I came to know that the judgment and decree under appeal, and subsequently subsequent to the filing of an execution petition. Thereafter, immediately I have taken steps to file the present appeal. Hence, there is a delay of 429 days.
What has happened?
Now, their objection is that there was no NOC filed at all, and the same counsel continued.
When did you come to know? Nothing.
But
No
only
details.
No
only,
date
only my lord.
matters.
That is at para 4.
Hmm.
Only my lord, after my lord, the judgment and decree, when the execution came to be filed, in connection with some other matter, my lord, I went to the JP Nagar sub-registrar. That date is not. After filing of my lord,
29 days, counsel.
after filing of execution.
Some details have to be there.
My lord may kindly come to my lord the objection filed by them. Their only objection, my lord, is that there was no NOC filed at all, my lord.
Hmm.
But the order sheet shows, my lord, there is an NOC filed.
Where
And
is
the new counsel, my lord,
where is the order sheet?
order sheet is not part of the records. Now, my lord, the possession is already given up. Only question which is liable to be determined, my lord, is with regard to the payment of rent, my lord. Possession, my lord, is already with them. That's why it can be condoned and it will be taken up, my lord, for admission.
He states that he has given possession in December 2020, my lords. He has filed his return
21.
statement in July 2021. Nowhere in the return statement he has stated that he has handed over the possession. It's a false affidavit.
December,
Possession is not handed over.
No, he has handed over the position in December 2022, my lords.
22.
22. In
According
the
to
affidavit,
appellant's
my
lord,
lords, he states that he has handed over the position to me in December 2020. He has filed his return statement in July 2021 before the court below.
according to the appellants, in December 2021, my lord, they have handed over the possession. According to the respondent, my lord, it is December 2022. Even after, my lord, December 22, when the execution was filed, even at that time, my lord, they don't mention, my lord, that possession is handed over. Up to the date of filing of, my lord, execution, they calculated, my lord, the rents and filed it, my lord. Even as on the date of decree itself, my lord,
What is there to show that you handed over in 2020?
nothing, my lord. It was a overall compromise. He gave the key, my lord, that is all, my lord. That is how, my lord, he did not appear in the court. Once, my lord, the possession is given, he chose, my lord, not to appear.
Yes, it's only a matter of when and how. Can you not settle it among yourselves?
We are ready. They have, my lord.
Let them settle before the court itself, my lord. What has happened? They have been beating around the bush for around 1 year, my lord. They come to this honorable court.
My lord, may I kindly
They
recollect?
submit that they want to settle the matter. They go before the executing court. They say submit the same thing, my lords. Not a pay has been paid till now, my lords.
And kindly recollect, my lord, the agreement, my lord, was in, my lord, February, my lord, 2020. Within 15 days, my lord, there was a lockdown. Not even a single day, my lord, he could operate, my lord, the restaurant. And, my lord, about 25 lakhs, my lord, he has invested, my lord, for renovation. Not even a single day, my lord, he did not, he could not, my lord, operate the premises.
See whether it can be.
7.5 lakh, my lord, the advance.
Let him
that is
approach,
lying
my
with
lord.
them.
He is not approaching at all. All words, no action.
My lord, may kindly condone the delay and refer the matter, my lord, to the mediation. We'll sit together and, my lord, somehow, my lord, we'll settle.
A very bald affidavit. No date is forthcoming. First
Now,
of
my
all.
lord, the execution is filed. There is an order of attachment. Any day, my lord, they are likely to take coercive steps. My lord. The days of, my lord, occupation is, my lord, the dispute. According to us, my lord, it is, my lord, December 2021. According to them, my lord, it is December 2022. That is the only, my lord, difference. We'll sit together, my lord, and just compromise.
The date may be fixed.
Yes, the learned counsel appearing on either side submit that there is a chance of settlement in the matter. List after a week.
Lord, there is an execution pending.
Date may be
Today,
fixed,
my lord, it is posted.
The meanwhile, further proceedings in execution. In the meanwhile, the
He has not challenged it, my lords. Execution proceedings, he has not challenged it.
Further proceedings in execution. It is agreed that further proceedings in execution shall not be precipitated till the next date.
Please, please.
Let's see. If there is no chance, then we'll hear the delay petition on its merits.
Please.
With this affidavit, it's difficult. Yes.
I'm for the appellant in this case, my lord. 1 month time is required to vacate the premises and hand over it, my lord.
No, last may see the order sheet.
Yes, last
9th April 2025. Learned counsel for the appellant filed by memo, etc.
Acknowledges receipt.
You have the memo filed by the appellant. Yeah. The appellant undertakes to vacate the premises within 2 months from today.
2 months from today.
That is 9/4. Is the date of the order.
Yes, it was over, my lord, because I have entered an sale agreement with the vendor, my lord. He's abroad. He's coming another 10 days. I have started already removing my belongings from the premises. Only thing is I have to get registered my sale deed and move it, my lord.
The sale consideration according to the agreement is 5 crores and odd. He has paid only 1 crore and odd. Time for that has lapsed. That cannot be enforced. Moreover, he is not prepared to pay 17 lakhs to me. He has paid an advance according to the agreement more than 1 crore. Balance is 4 crores and odd. In a criminal case filed against the husband of the appellant, he is convicted. He is not even prepared to pay 4 lakhs.
So I will vacate it, my lord. 9,92,000 rupees arrears of rent, my lord. Out of that 6 lakh I have deposited here.
That
The
is-
only thing is now I have entered into a sale agreement. I have to move it, my lord. I started moving another month, within a month, my lord. If it is prior to that, I will vacate it and I will hand over the key. And arrears of rent, my lord, I have to some time. Meanwhile,
When
because
you
I have
can
also.
pay more than 1 crore to the.
Yes, I paid 1 crore, my lord. Want to change my location, my lord. That's the reason I have given that. I am entered into a sale agreement also. Since he is in abroad, that I am not able to register it. So once it is registered, he will hand it over, my lord. He is coming anyway, coming in within 15 days. So I can move it, my lord. And he knows that I have also started removing my belongings, my lord.
Let him vacate within a week, hand over the key. Then I can think of giving up.
At least 2 weeks, my lord. Before that it happens, I will.
No, let the appeal be dismissed.
2 weeks.
Let the appeal be without driving me to file execution proceedings.
They have already filed
Counsel,
execution petition, my
yeah,
lord. It's pending.
Continue.
Submits that some more time is required to vacate the premises. 2 weeks' time is granted
Please.
as a last chance, list after 2 weeks.
Please.
To vacate,
To
otherwise.
vacate the premises.
And,
I will hand
and then pay the balance.
That has to be
That
decided, my
we'll
lord.
decide on that day. What time?
Please.
Date may be fixed. Otherwise.
Yes, after 2 weeks, give a date, please.
Please.
Lord's matter had come up for admission when the advocates were on boycott. Your lordships had issued notice, my lords. So I have sought for recalling of that order only to consider my application for ex parte order. That's it. Lords, a property which was subject matter of a mortgage is agreed to be sold with a condition that the owner defendant would clear the loan and then sell the property in my favor. 1 crore advance is paid. During the pendency, when the notice is issued, the property is brought to auction. Lords, then I seek permission of the court to deposit the money so that the property could be saved. The trial court allows the application. The owner challenges it before this honorable court. This honorable court says, let the consideration be paid to the bank and the keys and the possession will have to be kept with the court. Now, the trial court takes a view that there is no readiness and willingness on the ground that I was required to follow up with the bank to find out what is the due and should I have paid the money. This is that's the only reason which has been assigned so far as the readiness and willingness is concerned. The defendant took a stand that this is an agreement which is meant for security to a loan transaction, which contention, my lords, has been accepted by the trial court. I'm only requesting, my lord, that there can be an order of status quo regarding the possession and the keys, which was an order which was in force till the,
Is there an IA to recall?
yes, my lord, there is an application to recall. IA 1 of, IA 3 of 25, sorry. The trial court rewrites the contract, says that it was my obligation to have checked with the bank and then should have cleared it. But agreement specifically says that it is for him to clear the loan and then complete the transaction. The orders of the learned single judge, which was enforced in the disposal of the suit, is that the keys and the possession should be with the custody of the court. Because this was the order by virtue of which I was permitted to discharge the loan. So my apologies, my lords, I have only one copy in this.
The amounts have all been handed over now. The,
Lord's bank's loan is completely discharged by me.
yes.
If not for the bank loan having been discharged, the property would not have been there, my lords, for us to agitate.
Defendant number 1 is directed to refund 2 crore 79 lakhs.
Yes,
interest at 12%.
that is what is paid by us, my lords. Out of 4 crore 30 lakhs, 2 crore 79 lakhs is paid. 130 was paid earlier, and another 150 minutes was paid after these orders were passed by the learned single judge. And that's how the property was saved.
Original documents and keys regarding suit scheduled property deposited by defendant number 2 in the court shall be given to the custody of defendant number
Yes.
1. What should we do with this? Shall we recall the order and list it tomorrow?
Lordships.
Yes. Heard both sides. I heard the senior counsel appearing for the appellant. In view of the governments in the affidavit filed, the order dated so and so shall recall list tomorrow. For admission. That is the order which has now been recalled. Listed tomorrow.
Represent the appellants in the second connected
I'm
appeal.
very with the appellants in this case.
What has happened is this minute. So far
I
as
filed the memo for withdrawal. Withdrawal is considered, and the
Just a
return of
moment.
documents may be ordered with that.
in the connected matter for the appellant, these two appeals are against the same judgment and decree passed by the court below. My client is defendant number 1. Suit was dismissed against him on account of the plaintiffs not taking steps. Subsequently, without noticing that earlier order passed by the trial court decreed the suit. We were not aware of it. We had no opportunity because suit was dismissed. Then what happened in the final decree proceedings, they tried to get the decree, preliminary decree, enforced by means of dividing the properties, which included even the property purchased by me. Then we appeared in the final decree proceedings. And we said, since the suit is dismissed as against us, no question of final decree proceeding. And as a measure of abundant caution, we have filed the present appeal also because the final judgment of the court is against my client also. In the final decree proceedings, the latest development is FDP as against my client is dismissed. But in the meanwhile, these respondents who have sold sites to us, what had happened is they have precipitated the matter in the sense that after the decree came to be passed, they enter into a compromise, a collusive partition deed. On the basis of the partition deed, 27 guntas of land, which includes my property also, has been sold by them to different purchasers in the form of different portions of the land. I have filed the impleading application in my appeal, seeking to implead those purchasers also who, to whom these respondents 6 to 8 were the mischief mongers, they have sold the property. So that is the situation in which I am placed in the connected appeal. So far as their appeal is concerned, that appeal is filed by defendants 2 to 4. I cannot have any objection in their withdrawal of the appeal. So far as the giving back the documents are concerned, so they are asking for these series to be given back to them. Let them replace the certified copies because all those documents are pertaining to the portion purchased by them. And your lordship will make it clear.
Do that procedure, we will give the certificate copies and get back the originals.
My only request is your lordship may kindly make it clear that withdrawal of the appeal, which amounts to confirming of the decree passed with the trial court, has no effect so far as my appeal is concerned. That clarification may be made.
Yes, yes.
This is an IA filed. The learned counsel for the appellant has filed a memo seeking withdrawal of the appeal as not pressed and for return of the original documents marked as Annexure D series. Full stop. The learned counsel appearing for the appellant in the connected appeal submits that the appeal can be dismissed as withdrawn, however, without prejudice to the contentions of the appellant in the connected appeal and on the condition that the withdrawal of the appeal will have no effect on the contentions in his appeal. Full stop. In the above view of the matter, RFA number 160 of 2018 is dismissed as withdrawn. The documents produced by the appellant shall be returned to the appellant on proper identification and after replacing the documents with certified copies of the same.
Much obliged.
And your lordship may say it, that is their submission. Your
It
lordship.
is,
Your lordship has recorded their submission. Your lordship may pass an order saying that withdrawal of the appeal has no effect upon.
yes, it is made clear that withdrawal of appeal RFA number 160 of 2018 will not prejudice the contentions of the appellant in RFA 1244 of 2021.
In my case, what has happened is some process has to be taken out. What had happened is I had taken hand summons in this case, Milord. Respond number 1, Milord, has those hand summons were refused by some of the respondents, especially respond number 1 and also 6 to 8. 6 to 8. Milord.
If the
What
refusal is on record,
No, what
it
has
can be.
happened? Hand summons were refused. I have filed an affidavit. In addition to that, what has happened? Process given by issued by the court also, it has been refused by respond number 6, and respond number 8 it is unclaimed. It has returned. For these two persons, your lordship may hold this service sufficient, and I will take process to respond number 7, and also propose respond number 13 and respond number 1. So far as respondents 6 and 8 are concerned.
One also.
One, of course, hand summons have been refused. If our lordship permits.
Yes, it is submitted by the learned counsel for the appellant that notice duly taken out to R6 has been refused and notice to R8 is unclaimed. Notice to R6 and R8 is therefore held sufficient. The appellant shall take steps in respect of the remaining unserved.
Much obliged.
Please, Milords. The office objection is that no double cost title for the IA, for the LR application. Appellant number 7 is dead. Respondent number 1 is also dead. But the other objection is that I have not specified the number of days or date of death of respondent number 1. So it is for the other counsel to tell me on the which date he died, because I would not know.
The memo does not have the date of death.
He has not filed any memo.
Not filed memo.
He has not filed, because when I came to know that I had to move an application for the death of appellant number 7, they also told me, my clients also told me that the respondent number is also dead. So I have made an application. So I'm amended the cost title to the IAS. I'm filing, your lordship may kindly receive.
Please file it in the counter. Yes, the learned counsel for the appellant submits that the office objections are being complied with. List the registry to verify
if my application were to be allowed, there will be some progress, my lord. 2018 appeal. Paper books are being ready. It will be filed in a day or two. Correct.
Yes.
2 days time may kindly be given, my lords will take steps.
Yes, weeks time granted as sought.
Okay.
Paper book, 4 weeks time. Weeks time.
Relating to the steps, there is another application. The earlier there was an order of stay subject to deposit of 50% of the decretal amount. Thereafter, I paid 7,50,000 and sought the extension of time and granted. Thereafter, my lord, he has got the health issue, dislocation, and his native place is at Hyderabad. So that I filed that particular application for extension of time. Then, my lord, I paid the complete deposited amount with DD already submitted before this honorable court. Total, this one order of 50% is deposited. along with an application for extension of time. That application has to be considered.
My lord, appear for respondents 1 to 5, my lord. The sums that they have deposited are not 50% of the entire decretal amount, my lord. 50% is calculated only on the principal amount. Whereas the interest which has been awarded by the court, my EP is the execution petition that I have filed.
How
my
much
lord,
is the total decretal amount?
total decretal amount is 1 crore 4 lakhs, my lord, and that is with 9% interest. So with interest itself amounts to another 60 lakhs. So about 1.65 lakhs would be the decretal amount, because the order of stay also says 50% of the decretal amount as of today. So that means they had to include interest. So about 82
Interest
lakhs.
has to be included. Where is the doubt?
So
Yes.
another 30 lakhs is a short deposit which they have to do.
Please deposit the entire amount.
I will make.
Yes, it is submitted.
Remaining this one on interest.
The interest portion.
Yes, it is submitted by the learned counsel for the appellant that 50% of the principal amount has already been deposited, and that the remaining amount, which represents interest until the date of the interim order, will be deposited within
2 weeks.
within 2 weeks. Yes.
My lord, and
this-
R6, my lord, notice is not to serve
Notice,
to
I will
R6. It is
take steps,
company. Please, it is
Yes.
represented by the IRP.
List after 2 weeks.
And
In the meanwhile,
interim
notice
order.
to R6 shall also, steps to take notice to R6 shall also be.
Interim order may be extended.
Interim order shall stand extended till the next date of hearing, provided all the
Yes, ma'am. Yes.
conditions are complied.
But date could be given, my lord. Date can. Of reserves.
33 and 34 SC/ST matters delay of 20 years.
I see 2 weeks time to file NOC Vakalatnama and compare all
Last time-
subjects. I'm filing the memo of undertaking with respect to
Last time they took time saying that the order which is pending before Supreme, that also has been confirmed.
When,
I
when
think
was
you
it confirmed?
Millard, 1/4/2025.
1/4.
a date be fixed, your lordships will.
A short date.
During this week only. This is the only point, there is nothing to be concerned.
At least 1 week time, your lordships, we need to compare all subjections.
Not this week, not this week. We'll list it next week, after a week.
And your last judgments also is there, Millard.
List it. That- Okay.
And your last judgments also, Millard, number of judgments.
Yes, yes. 33 and 34, both 33 and 34. Show the name also.
Same.
Week's time. Week's time.
In serial number 35 and 36, I appear for appellant, my lord. Lord, PF has been paid, my lord.
That is the office objection.
Please.
Only office objection.
Only office objection.
Learned counsel for the appellant submits that office objections stand complied with. Further, it is submitted that the translated copies of relevant documents will be made available as required by court. The registry to verify and post for admission
Please, my lord.
after 3 weeks, after 2 weeks.
Grateful, my lord.
This is awaited because the other private respondents are the relatives. They are all the children. They have received, some of them have received, some of the.
R2, R4, R7.
Yes, they are all the legal representatives of original petitioners.
Await service of notice.
In this matter, please, I am not feeling the 1 week may be granted, please, time, please.
Office objections, 8 numbers. Weeks time sought for to comply with the office objections. List after week.
Week's time, my lord, I'll take.
674 days delay. Yes, week's time sought for to comply with the office objections.
Appeal the petition place for time for 2 weeks, my lord.
Guru ಬರ್ತಾ ಇಲ್ಲ
Yes, 2 weeks time granted as sought for.
42, your
42, my lords. My lords, pray for 2 weeks time, my lords. Apologies, my lords. Sincere
Lordship.
3 office objections, 15th time.
apologies.
What are the office objections?
But have to submit the sorry, apologies, my lords.
Make
The
submission,
typed
my lord.
copy of the annexure P, R1, R2, and R. It's ready, my lords. It's already ready, my lords. I'll just affix it, my lords.
During the course of the
may be
day.
granted. Huh?
During the course of the day.
During the course of the day.
It is 15th time, counsel.
Apologies, my lords.
Please do it during the course of the day.
It's,
Why not?
it's weeks.
It is, then what else?
No, my lords.
What are the other office objections?
No, my lords. It's not that, my lords.
Lordship, my submission, my lord, there is a reinstatement order in employment 2016. Thereafter, they lost case everywhere, my lord, before the tribunal as well as appellate tribunal and before the learned single judge, my lord. Now she has left with only hardly 1 year service, my lord. There is a gross violation of natural justice. That is a finding given by all the
There is
authorities.
stay as against your, is there a stay against
No,
your?
no, my lord. But it is to
Don't
be
you
heard
say-
earliest, but they are, it is listed 15 time, my lord. That time may kindly be fixed, my lord. Any?
Have you filed contempt?
No, because of this pendency of writ appeal, my lord. That's
What pendency, counsel? When the matter is pending office objections for 15 times, you call that pendency? There is no interim order as against you.
no, my lord.
Yes,
Any date next week, my lord. Let them come.
yes, week's time granted as a last chance.
Apologies.
Please see that it is done within
Yes,
the
my
week.
lords. Yes, my lords.
Serial number 44, my lord.
I'm for appellant, my lord. I'll take steps on regarding R5, my lord.
Week's time.
Please, publish.
My lord, I appear for the appellant in this case, my lord.
I'm sorry, you're not appearing.
Please, Lord, I am for the appellant. Serial
Yes.
number 44, my lord.
Yes.
Lord, the office objections are not survived for consideration, my lord. Your lordship may kindly see the order dated 21/1/2025.
Hmm.
Lord,
What is the order?
Lord, the notice came to be ordered to the response number 4 and 5.
But still
Lord,
amended memo is not filed.
Lord, they are already, my lord, I made them as a party response number 4 and 5. In the writ appeal, page number 4 may kindly be seen, my lord. Page number 4.
Please correct the main memorandum, counsel. It is still not corrected.
Lord, I made them as a party, my lord, the LS of the late Srinivas Murthy as response number
That may
4
be
and 5.
so, but the main appeal is still not corrected. The cause title is not corrected. Please do the needful. Week's time granted to do the needful.
Please.
Memo for retirement can be accepted. Memo for retirement filed by the advocate for the appellant is accepted. A week's time is granted to comply with the office objections as a last chance. List after a week. The party in person has not appeared before this court. However, week's time is granted to comply with the 2 weeks time is granted to comply with the office objections. Court fee. Week's time.
appear for appellant, my lords. I request for 2 days time, my lords, will comply with the office objection.
Yes. Learned counsel seeks 2 days time to comply with the office objections.
Like,
Time granted is sought for.
I am for the appellant in this case, my lord. With regard to the office objections, I have already complied, and the same objections have been raised on many occasions. Page number 18 of my memorandum of appeal and para number 36, with regard to the valuation para, that I have already mentioned, my lord. That's already there. 2 times I have corrected it, and
Learned counsel for the appellant submits that the office objections stand complied with and that correct court fee has been paid.
Please, I have done it. I have done it. And
Office to verify and send up for
my
admission.
submission, please, my lord.
For admission, it will come up.
Please.
The office shall verify and put it up for admission.
No, with regard to, I have moved it before this honorable court for the stay of the execution proceedings in this case, because it is for the return of the sale consideration amount whatsoever I have received. It is the breach of the plaintiff. I am the defendant. It is the defendant's appeal. The plaintiff has paid me the 35 lakhs of rupees as the sale consideration amount with regard to the sale agreement, which we have executed. But the breach is of the plaintiff, and he is not ready to get the property executed, sale deed get executed. I am ready, even today I am ready to execute the sale deed. But the plaintiff has been making the allegations against me, and the decree has been passed in that regard.
Let it come up for admission.
Please. No, stay may kindly be granted. The conditional stay may kindly be granted, my lord. It's on 11th for the auction sale of the suit scheduled property. That is my humble submission. I have been moving it, and this is the office objection. Frequently the same objections have been raised, despite my compliance. That's my humble submission.
Does it comply? What does the office say? Verify and put it up tomorrow.
Please. Tomorrow, sorry, tomorrow I'm out of station.
Day after is the 11th.
Day after. Kindly have it on 11th. I'll be here. Please.
Not in this case also, my lordship. The lordship had to take the orders dated 4/2/2025.
4?
Not 4/2/2025.
Yes.
Notes office raised the objection regarding to the payment of the court fee.
Yes.
Notes it's our case, notes that there is no due, notes with respect to the arrears of rent. Whatever the rent, notes till date we have paid. Therefore, notes the payment, notes of the court fee of the mean profit would not arise. Not by orders dated 4/2/2025.
Yes.
Once our submission was taken note, and not this court passed a order to consider our submission and make a office note.
Though the submission is contested by the learned counsel for the respondent stating that an amount of 8.50 lakhs is still payable by the appellant, in any case, registry shall consider submission and give its report. What is the report?
But once again, notes the offices raises the very same objection.
What is the report put up? I don't find any report.
Court fees calculated on damages. So there is no arrears.
Lord, according to me, my lord, my instructions are that even on date, my lord, 6 lakhs is due as arrears of rent, my lord. So I will furnish a calculation.
No, I will produce the rent receipts up to date. My lordship may have this matter tomorrow. I will file a memo with all rent receipts.
Please see what orders have been passed. The registry was asked to look into it, look into the submission and submit a report. Please make it available
Please,
there.
Needful has been done.
Notice you've
Please,
complied.
please. Today, needful has been.
You submitted that PF and forces has been paid today. List after service is complete.
Please, please.
Refused. The registry has reported that notice taken to R3, R5 and R6 has been returned with the Shara addressee refused. The notice of service to R3, R5 and R6 is therefore held sufficient. List after, oh, everybody is, no, there is R1 and R2, there is appearance.
I am for R1 and R2 in this case.
Yes. R3, R5, R6 held
Yes, Your
sufficient.
Worship.
Yes, list out. Office objections, 1 week.
Lord, I appeal for responding to Lord, they have to file a paperwork.
I request a week's accommodation. I'll file.
Week will do.
Also. Please,
Learned Counsel takes a week's time to
please.
file paper book list after paper book is on record.
Well, I appear
19
for
and
the
22, my lord, we
apply
have not
number.
received any copies of the.
Are
I'll
19
happen to
and
see our
24?
19 and 22.
22 or 24?
22. We happen to see our name in the cause list and we're appearing. We have not received any copies.
I'll serve
And-
the copy, my lords.
Awaiting service.
And there
of
was no
notice
caveat, my lords.
For 19 and 24.
My lords,
Yes, Learned Counsel.
I request.
kindly, my-
So-and-so Learned
Lords.
Counsel submits that he represents our 19 and 22. And that no copies of the appeal have been received. The Learned Counsel for the appellant submits
my lords,
that.
may I
copies
make
of the-
submission?
Just a moment, please.
Aye.
That copies of the appeal shall be served at the council appearing for R 19 and 22. The Learned Counsel shall file wakalat, undertakes to file wakalat.
Yes, undertakes to file.
Yes. Yes.
My lords, this earlier on 20th 5/2025, my lords, there was an interim order has been granted by this honorable court, my lords. In that, my lords, while preferring this appeal, my lords, I was filed an application for interim order, my lords. In that, there is an affidavit, my lords. In that, the item number 3, only the item number 3 was mentioned, my lords. It was by oversight, my lords. That has to be corrected, and I have filed, in support of that, I have filed an affidavit, my lords. Along with the one more application also, I have filed, my lords. To that effect, the item number 1, 2 also, the interim order could be granted, my lords. In the trial court also, there was an interim order, my lords. Upon that, they had the advantage of that.
No.
It could be granted, my lords.
My lord, my humble submission is there has been a delay of 4 years in filing of this appeal. Without condonation of delay, without admitting it, this honorable
No,
court
no,
could
may I
not.
make submission,
Please
madam?
let me finish. Please. Without condoning delay and without admitting the appeal, this honorable court could not have proceeded to pass an injunction order in.
That is
So
absolutely
just
wrong,
because
my
they enjoyed an injunction during the pendency of the suit doesn't mean that 4 years delay can be simply overlooked and grant an ex parte injunction without hearing me, my lord.
Lords, kindly.
Now, in the last 4 years, some amount of third-party interests have already been created. Now, all the subsequent purchases are now be suffered because this pendants will not apply where the limitation period has already lapsed.
No, my lords.
So
There is
kindly,
a-
we may be heard before the injunction is
Lords,
granted. I request
May I
the
make a submission, my lords?
injunction
That
not
is
to be extended, my lord.
What the learned counsel of the respondent, my lords, is making a false submission, my lords. The delay has been already excluded, my lords, in the civil revision petition by this honorable court, my lords.
Where is
The
that?
delay was.
Where is that?
Kindly see, my lords, in my appeal, my lords. Page 15, para 14, my lords.
Page?
Page 15 of the appeal, my lords. In para 14. The limitation was excluded, my lords, to prefer this appeal. Earlier, it was
initially approached this code WP
Yes, my
1617
lord.
of 20.
That has been converted to the CRP.
Petition was converted into CRP. Matter was accordingly disposed. However, which is sailed impugned order dated 18/8/21 came to be dismissed. Thereafter, appellants preferred review petition. Upon consideration, review petition number so-and-so was allowed. Order dated 19/22 passed in CRP was recalled. Petition was restored. Permit the appellants to withdraw the CRP, accordingly dismiss the same as withdrawn while granting liberty to file the present appeal. Where does it say that the time has been
I shall, my lords.
dismissing the civil revision petition?
For a moment, my lords.
Reserve liberty to file. That does
That
not
is
mean.
reserve liberty to file an appeal as well as the limitation was excluded, my lords.
Where
I'll
does it
just-
say? Further directed that so shall be taken into consideration for the purpose of computing the period of limitation filing the appeal. That's all.
Yes,
Does not say that it shall be excluded.
it is excluded, my lords. I'll just
Completely
produce that
different
copy.
situation altogether. When you say that you approached this court, preferred a CRP was pending,
Yes, ma'am.
and you withdrew it.
My lords, earlier,
Has it been specifically excluded? Is the
yes, there is a specific order, my lords. There is a specific. That is why I sought for this interim order, my lords. I'll just show.
Please produce it. And during the pendency of the CRP, there was an interim order?
There was no interim order, my lords. Why? My only submission is that, my lords, in the trial court, there was an interim order. Subsequently, 7 to 11 was filed, and that has been allowed only on the ground of the court fees has to be payable, my lord. The deficit of court fees, my lord. That is based on the joint development agreement was entered into between the appellant and the respondent. My lord, these appellant had never entered into an JD, my lords. So based on that,
You are
the application
landowners.
was allowed.
Your landowners.
I am the landowners, my lord. There was an interim order. Subsequently, the writ petition by
Please file
oversight,
your
the writ
vakalat.
petition was
We'll
filed.
hear this on a near date.
My lords,
Should
kindly,
be after-
it may be passed on, my lords. I'll convince this court and I'll produce.
Have any papers at all, my lord?
Please serve the copies.
I'll serve
Yes.
the right now, my lords. I'll serve
Tomorrow.
the copy, my lords.
Any
Tomorrow.
tomorrow, my lord.
It may be.
Yes. Don't do anything. Item 1. Let's do item 1.
For the petitioner, my lord.
Who appears for the respondent?
They had filed their
Objections have
objections.
been filed.
Yes, they had filed it in the morning.
The child is here.
Child is in Bangalore,
How old is the child?
4 years old.
You are the
I'm the father.
father.
I know the brief facts of the case are that both the father and the mother were gainfully employed in USA, in California.
Shall we take this up a little later?
Yes,
Because the other side has to be here. Maybe 2:30?
maybe 2:30.
2:30? MSME Act is here. MSME Act. Hmm.
Respondent in this matter.
5.
MFA 4959 of 2020.
4959 is item 4.
Still number 4. I'm
Yes.
sorry, my lord, I was outside itself. May I proceed?
Yes, this is with regard to the serving of
Arbitral,
notice.
correct, my lord. My lord, may kindly take my appeal, my lord. I'll very briefly tell what the matter is all about. My lord, may kindly take page number 35.
Concrete pump.
Yes, my lord. My lord, this matter pertains
Damage
to...
due to floods.
Correct, my lord, absolutely correct. My lord, may kindly take page 35. I was carrying out a project in Mandya, my lord, at Mahadevpura, Srirangapatna Taluk. At page 35, my lord. The address is Mahadevpura Small Hydroelectric Project, Mahadevpura, Srirangapatna Taluk, Mandya district. For that, I required a stationary concrete pump, which is 1409D. My request, my lord, to kindly highlight 1409D, my lord. It is of great significance. I'll come to it later. 1409D. So, my lord, on 18th June, I placed a purchase order for this particular 1409D concrete pump, whose value is approximately 50 lakhs, my lord, 49,35,270. Your Honor, may kindly come to page 36. The next page, my lord. Respondent in this case, respondent number 2, which is the contesting respondent, HDB, has issued me a welcome letter wherein it has acknowledged my application and has reimbursed 39,48,000 as a loan amount, my lord.
How much?
39,48,000. And the installment amount?
48,000.
Yes, my lord. 39,48,000. And the installment dues, installment amount would be 1,35,250. This was on the 27th of July, 2012, my lord.
27?
7, 2012, my lord. So the loan amount was 39,48,000. The installment amount is 1,35,250. The schedule of payments was laid down at page number 37, my lord. Your Honor has the schedule of payment. I have made the initial payment, my lord. In fact, the first deposit that has to come from me. For I had paid 7,40,000 from my own amount, and I was paying the installments towards this concrete pump. Now, this concrete pump was delivered to me on the June of 2012.
Yes.
The delivery order is at page 38, my lord.
58.
38, my lord.
38.
This is issued by respondent number 2. This also is for model 1409D, my lord. Your Honor, may kindly highlight that. 1409D. Whatever are the previous documents has been affirmed over here, wherein my name is reflected. The total value is 49 lakh odd amount. Finance approved is 13,48,000.
Yes.
And the disbursement was reflected, my lord. At page 39 is the delivery challan. Page 39, my lord, issued by the company, which has given me the concrete pump. Your Honor would see the model reflected is Putzmeister Stationary Concrete Pump BSA 1409D. It's the same model, my lord. The accessories list is the next. Now, here is the thing, my lord. Subsequent to the equipment being delivered to me in November of 2012,
yes,
this equipment got damaged due to floods, my lord. And so it had to be sent across for repairs. Your Honor, may please come to page 43.
Yes.
This is for when the vehicle is being transported, you have to give the certificate. It is not for resale. So we have issued this letter on 26 November 2012, which goes on to say we have requested Mrs. Putzmeister Concrete Machines, Saptagiri, 5th Cross, HBR, Kalyan Nagar, to take the damaged concrete pump BSA 1409D with accessories bearing machine number so and so to their industrial area at Goa for complete repair and return. It is once again confirmed that the machine is not for sale or resale. Because the machine has to travel from one state to another, a declaration is required, which I have given, my lord.
Yes.
The company has, on the next page, my lord, page 44, the company has received the good. That puts Master, that's a delivery challan. Page 45 is a very crucial document. It is the insurance claim intimation form by New India Insurance Company,
Yes.
wherein the policyholder is my name. The floods occurred during the policy period itself.
Yes.
And your honor would see that the estimated loss is total loss for sum of 50 lakhs. The insurance claim was raised, the type of machinery is machinery, and at the nature of machinery, Woodsmeister Stationery Concrete from BSA 1409D. I'm sorry, I'm repeating this again and again because there is a significance to it. 1409D.
Yes.
After this claim intimation form, I've been given an acknowledgement by the insurance company at page 46.
Yes.
May I read this, my lord? May I read this? The
Yes.
surveyor has submitted his report assessing the loss based on the papers made available to him. Surveyor has appointed that damaged vehicle has not been repaired so far, but otherwise the claim is in order. They stated that you'll be requiring a letter from us stating the claim is admissible in policy, and we're going to process the claim on submission of final for the repairer as repair was session damages has the insurance report. This with regards to the insurance survey report, my lord. This is on 28th of January 2013. So, my lord, as on this date, the vehicle was damaged, taken by the manufacturer. Insurance claim is in process. Survey is taking charge. I neither have the vehicle nor of it, and it's a total loss claim, my lord. After a lapse of 8 months, on September 29, 2014, a year and 8 months, 1 year and 8 months, my lord. This is the last letter from the insurance company. At page 47, I received the email from respondent stating that, now here my lord may see reference, vehicle make and registration number, concrete pump BSA 1405D. For the first time, a different model number and registration number non-registered. Whereas all throughout, my has been 1409D, a different model altogether. And this particular thing does not pertain to me, is my case, my lord. On the basis of this, they have made a claim
Yes.
of 15,82,952. This is in September of 2014. The Anu would see the amount is reflected at page 47.
The amount
After sale of the vehicle, there is a loss of 15,82,000. Now, this begs the question that whether this was a total loss, an insurance claim, or a resale. I pause here for a moment, my lord. I received 1409 model from them. I was using it for 2-3 months, and this comes with a 12 months manufacturer warranty. It got damaged due to floods. I have given the declaration not for resale, sent it back to Goa. They have acknowledged it. Insurance claim is raised. They have given correspondence to me. I do not have the machine with me. As it is with the insurance company, as against the financial institution, I was aware. A year and 8 months later, I get a mail with regards to a very different model number. That has nothing to do with me. For aforesaid asking for 15 lakhs. I have nothing to do with it. Absolutely no connection whatsoever. Subsequent to this is the question that is raised. Whether this was repossessed and sold, or was there an insurance claim to this? Was it a total loss? Did they get the amount from the insurance company? Did they not get it? Because the model number is different. None of this is forthcoming. In this backdrop, it appears that some arbitration proceedings were held and the award has been secured ex parte award itself. Now, there's a dispute with regards to whether notice of the arbitration proceeding has been served or not. I'll come to that subsequently. On the merit, it is with regards to the variation in a concrete pump's model numbers, which show that there is more than what meets the eye. It is not a simple case where I have defaulted and arbitration proceedings have initiated. I'd be completely fine with it. I would have shown that, okay, listen, this is the loss, this is the insurance company. I never had it for more than 3 months. This is the loss that I have suffered on account of this. And I myself have paid 7.5 lakhs for using the machine just for 3 months. And if this insurance claim has been realized and he has got 50 lakhs, I am entitled to a share in that because his payment is only 39 lakhs. That is the crux of the matter. Now, here are two aspects to this, my lord. The arbitral award is an ex parte award. There is dispute whether the arbitration notice was served or not itself. But however, my question is this. It is my stand that when she filed the execution petition, I came to know about this. I immediately, and this is on record, my lord. I can take the documents a lot because this is not disputed. These are court proceedings. I filed an application, a copy application for the receipt of the arbitral award in the execution. That came to be rejected on the ground that original is not filed. Subsequently, I filed an application for discovery of documents, calling upon him to file the arbitral award. Once he gave the arbitral award and I receive it, within the stipulated period, I filed arbitration suit, my lord. In the arbitration suit, he files an application under section 36 saying that more than 90 days has passed and the arbitral award passed in 2013 without getting into the evidence, without getting into whether it's been served or not. On the basis of submissions, no evidence has been recorded. The suit has been dismissed. It is my speculation that is a fit case for the matter to be remanded back and let the issue be framed on whether the notice was served, whether there's a delay or not, because end of the day, all these documents have to be looked into, whether I've been given notice or not and all of it. They have filed a statement of objections where they have produced two documents with alleged seals and signatures. Let the lower court have the benefit of it. Let me be put into witness box and show whether it's been served or not. Without any of this taking to a hasty conclusion that no, this without 90 days would not be appropriate in this case is my submission, my lord.
Yes.
I'm sorry, first of all, I struck in the quarter numbers. My lord, in this notice clearly served on 13/8 that acknowledgement also produced before your lordship on the statement of objection on the page number 10 and 11 of my statement of objection. The notices are served. The honorable trial court also recorded in their judgment.
Produced before the trial court?
Yes, my lord. That original
documents were produced?
Yes, my lord. All originals arbitration file has been produced before the trial judge, your lordship. In that, the page number 30 of the appeal, your lordship. Page number 30, it is clearly mentioned in the para number 11, point number 2. So again, the then the acknowledgement was not written. So again, the sent one more notice and it was duly served upon the petitioner. However, the petitioner documents clearly show that the acknowledgement of 14/8/2013 sent by the petition number 1 and 2 is duly served upon them. It was sent by the authorized signatory Shivkumar. The notices dated 31/8/2013 also sent served upon the petitioner number 1 and 2, and this acknowledgement also sent by the Shivkumar. So here the arbitration notices as well as the award also served on so and so date manner. Hence, this ground may be rejected. And now after serving they have to approach the court, but they have not done. So there is a limitation also, your lordship. Only the appeal memo they have taken as notice is not served. It is notice is clearly served to them. There is a seal also, my lord. Company seal also there in the postal acknowledgement, your lordship. Humble request, your lordship, is kindly dismiss the petition because there is no limitation and notice as served. And whatever is there.
Court copies affixed postal receipt dated 6/11/2013. Postal acknowledgement card shows arbitration award copy duly served on 9/11/2013.
Well, and my statement of objection, I produced the acknowledgements and originals also produced before the entire arbitration proceedings has been before the lower court, my lord. This page number 12, your lordship. Page number 10, it will start. It is 13/11/2016, 2013, your lordship. And second one, 13/10/2013, your lordship. And the arbitration dispute notice has served on 31/8/2013, your lordship. And the notice the acknowledgements also page number 13, your lordship. 31/8/2013. The Sierra construction, Sierra is there, seal is there, my lord, in the acknowledgements. The originals has been produced before the trial court, your lordship. The copies are coming like this one. Page number 10 to 13, your lordship. 13 is the postal acknowledgements, my lord.
Yes.
And received a signature also is there, my lord. 5/9/2013, and seal also there, your lordship. Shivkumar, it is mentioned in was received the acknowledgement also. Shivkumar name also is mentioned, the signature. And page 13, your lordship.
13.
My statement of objections, your lordship. R3, your lordship.
Several page numbers and
In my statement of objections, Your Lordship.
Yes, in your statement of objections 10, 11, 12.
Last page, Your Lordship. Last page before, my Lord.
Yes.
In the 13, it is first acknowledgement, my Lord. Shivakumar, 5/9/2013, signature is there, my date also there, seal also there, my Lord. And again, this down also there is a seals and signatures, my Lord.
Yes.
May I respond to this? Two aspects, my lord. After filing of the memorandum of appeal, I have urged all these aspects which I have argued before my court with regards to the model variation number, amount being paid, total loss, all of it. No response, any of it. Till date, they have not come clean whether this insurance claim was realized, not realized, whether got the money, not got the money, what. There's no statement forthcoming from them about this.
Yes.
Lord, there is absolutely no response. Even till now, they've not made the stand clear whether the equipment that for which they had financed, they've got the money from the insurance company, not got it, or because end of the day, it is this, my lord. If they have received the money from insurance company, then the question of me making any payment does not arise. There is a claim from the new insurance company for the same model number. The claim they're making as against me is for a different model altogether. Once the appeal was filed, they've come forward and filed an application. It is on the way of interlocutory application that the suit has been dismissed. Only on the ground with regards to this period of limitation. Limitation is a mixed question of fact and law. If these documents
That
have to
point,
be
my lord,
may I just
I'll
complete?
clarify. Okay,
May I just complete? A limitation question is a question of facts and law. End of the day, these documents you seek to rely upon, issue has to be framed on the preliminary aspect, and I'll be able to demonstrate as to how this notice was not served and how these aspects are premature, and I'm within the limitation period. Subsequent, if the court comes to conclusion, is a different aspect. At the preliminary level itself, on the basis of IA, can the court hold that this is beyond the period of limitation, which is what the court has done? The documents so produced have been summoned from the arbitrator, but at no point in time have had the benefit of either proving its correctness or otherwise. End of the day, I'm at a situation over here where a claim made 10 years ago on the basis of my usage of a machine for 3 months, I'm being asked to pay 15 lakhs along with now interest of 10 years, which is wholly unjust and completely unfair. In the event, if you see, my lord, there are two aspects. One which I would urge is the merits. I've taken a machine for which I paid 7 lakh, used it for 3 months. They have got the money from the insurance company. Some other machine with different model number, they're trying to have the recovery from me.
Contentions on merits have to be urged within the time as
True,
provided
my lord.
by
True,
the
my lord.
statute. What does 34 say?
True, my lord. I'll come to that. That was the first part. The second part, my lord, the aspect of 36(3) clearly says that within 90 days from the receipt of arbitral award. The question is, when have I received the arbitral award? There are two questions of fact. It is their contention that I received the arbitral award as early as in 2013. It has been my contention, which has been urged in the execution petition as well as in the arbitration suit, that I got this only during the pendency of the execution petition. I had filed application for discovery. That is when I got it. Whether contention is correct or not is something that the lower court has to decide. If the lower court decides that I had got the arbitral award much before it, then I'm beyond the scope of limitation. But to do that, I should be given a fair chance to lead my evidence to adduce it and show us whether I got it or not. My lord, I'm perfectly on that. I might have a very good case on merits. I have to urge it within the stipulated time period, but give me an opportunity to do so. I file my petition. You come ahead and file application saying, no, this is not that. Because of this, you urge it by an affidavit. You ask me to file objection and you decide it. These documents which are relied upon, should I not have the benefit of showing the correctness or otherwise? If the matter is remanded back to trial court, only to decide on the limited question of whether this is within the scope of limitation or not, that would be, in my opinion, the most fair thing to do, because that would give me an opportunity to showcase whether this is within the 90 days period or not. Because the language is very clear. In fact, it goes on to say it is 90 days from the date of receipt of arbitral award. Application may not be for setting aside may not be made after 3 months, elapsed on the date on which the party making the application had received the arbitral award.
Yes.
So, my lord, it is my contention that the date of receipt of arbitral award is of great significance, which cannot be primarily and summarily decided on the basis of assertions made in an interlocutory application. It is as good as deciding the issue on maintainability without even having any documents produced or provided for, and the court taking a superficial view of the whole matter.
Yes.
It would definitely prejudice my rights to regarding this, my lord.
Yes, what do you say?
My lord, one answer for this question, the insurance, he is the insurer, my lordship. He can get any document from the insurance company. Because he has insurance, he has paid the premium and he have every right to collect that. That can be looked here, my lord. He has challenged only the arbitration award. For arbitration award, he has to challenge within 90 days as per this once a month. And arbitration award also served, notice also served, everything is served. He has not come before this arbitration tribunal. After 3 years, he has preferred the arbitration suit before the sessions judge, your lordship. This is what, hence my
Yes.
report.
Reserved.
Lord, most grateful for a patient hearing, my lord.
Arbitration award also is served, my lord.
I appeal for the respondents in this matter.
Yes.
What could I take my lord for a minute? Page number 14. Sorry, my lord. If my lord, time is page number 35 in the reasoning.
35.
The reasoning. Or my lord can say at paragraph 20 of the judgment. The reasons. Paragraph 20.
Yes.
The point number 2, I'll come straight to it. So what happened, my lord, is that I had filed 2 applications to produce certain documents which are germane to the subject matter under Article 41. The Honorable Civil Court, my lord, would reject my applications on the ground, my lord, that the Code of Civil Procedure is not. I'll take my lord to this particular paragraph. IA number 3 and 4 are filed in section 19 and 27 of the Arbitration Act. My lord, takes my lord, section 19 Act. It specifically states the arbitral tribunal shall not be bound by the CPC or the Indian Evidence Act. The parties are free to agree on procedure to be followed by the tribunal in conducting proceedings, and if no such agreement is entered between the parties, then the arbitral tribunal may conduct the proceedings in the manner it confers appropriately. The arbitral tribunal is having passed to determine the admissibility, relevance, utility, weight of any evidence. Hence, it is made clear under the provision that the provision of CPC are not applicable to proceedings which are conducting under provisions of Arbitration and Miscellaneous Act. Then, my lord, in paragraph 22, my lord, as discussed earlier, the provision of CPC is not at all applicable to Arbitration and Miscellaneous Act. Hence, invoking provisions of Order 27, 41 Rule 27 of CPC is not correct. If the respondent establishes case under 27 Arbitration and Miscellaneous Act, then the IA will be allowed, and so on. And, my lord, my application gets rejected. My first submission of response is to you, it's a different issue, my lord, whether the court can examine it. But the court says, I am not even, it does not even, it refuses to accept your refusals. Which, my lord, is the first error committed. But I rely upon my judgment of the Honorable Supreme Court. Based on the point. There, my lord, earlier, my lord, there's a judgment of the Honorable Supreme Court visa developers. That is before the amendment, which says that applications or evidences, etc., could be permitted in an appeal. Subsequently, it was watered down sense, my lord, that amendments took place. I concede, my lord, that it has become more stringent. The asking for considering an evidence in an appeal, that is section 34, application 34, is that the court will have to see whether it is part of records, whether it is necessary, etc., whether it is frivolous. But here it is completely different. The court says CPC is not applicable. That's the first error, my lord, I would point out, as far as this thing is concerned. Now, my lord, I will also take my lord to the award.
What essentially is the dispute between you?
My lord, what happened? Sorry.
The amount paid.
Facts in the case are that the appellant and the respondent are partners of the firm. They bought a property. By paying sale consideration, taking loans. Subsequently, there were disputes between the parties, and he would issue a notice seeking for conciliation, saying that he needs to divide the property under weeks and months and for some other terms of accounts, etc. that I will use. But I denied that. And a dispute is raised, an application is filed in section 11. And my first submission is that the section 11 application, the notice as contemplated in section 11 is not issued. That goes to the root of the matter. I come to that. Then, my lord, proceedings initiated from the learned arbitrator. And the learned arbitrator, my lord, partitions the property and says A is entitled to this property, B is entitled to this property, which cannot be. Partition cannot identify the property because, my lord, that is the realm of civil court wherein, my lord, a commissioner has to be appointed. Whether my property, the value of that, everything has to be. If the court felt that both of us are equally entitled, then the court should have passed a preliminary decree like what is done in the civil court, wherein both of them are entitled to 50%. That is not done. The learned arbitrator says the one on the main road facing main road goes to him, the one behind it. So, my lord, it is not an equal distribution. Because, my lord, while dividing a property, that is why the FTP is done, my lord, commissioner has to be appointed. A commissioner will have to see whether both properties are same, whether value is same. All that, my lord, endeavor is not done.
Why can an arbitration not undertake that function? What?
Well, it's my case, my lord, the property which is given here is not in the same.
It's not the question. Question is, when you say that in a partition suit, it has to be done in a particular manner. What is the provision which says that that is the manner in which the arbitrator has to do?
That is because, my lord, what has happened is a claim is made by the claimant. He asks for this portion of the property, which is just plainly given. So, my lord, it is like this. This particular property is facing on highway. Big property. It is divided into two portions. The front portion, my lord, or one of the portions which is more valuable, is given. The other portion is given.
Did you not raise an objection with regard to the claim as to how the property is to be divided?
Lord, I would say, yes, I've done all that.
Therefore, that is an issue which could have been decided by the arbitrator.
No, my lord, my case was that partition could not have been done at all. My case was that it should not have been done at all. The court says we had rights. As far as sharing of the property is concerned, my lord, I had no objection. Probably, yes, 50%. I'm not considering, let us say it's good. But giving this particular piece of property was wrong.
Please show us what was the claim before the arbitrator.
My lord, may kindly see page 1, my lord, claim petition.
My lords, I am passing on the paperwork with translation. Only 2 documents are relevant in this matter. Two sets are there.
Yes. Direct for bifurcating scheduled property into 2 equal halves in terms of the sketch produced, along with legal notice dated 7/10/15, and allot any one portion to the claimants. Yes.
And direct respond to reimburse the claimants in excess of claimants 50%, etc. Direct response to pay the balance of the loan, interest to down pay, direct response to pay amount of so as calculation, etc.
This was the claim. What was your submission of objections to the claim?
That page 10, my lords.
Did you have a contention that the 2 halves are not equal?
No, that was not so because the claim he doesn't make such a thing at all.
Absolutely.
No, he only says give any one of it. The learned arbitrator will go one step ahead and says this is the property which has to be given to him. My lord, may kindly see the operating portion of the award. It's in the main paper book at page 108. I'll take that directly from you.
So how the property was to be divided was not an issue that was raised at all.
No.
No.
No. Therefore, now what does the award say?
The first portion is scheduled with the legal notice.
Just a moment. Where is it?
Award is in the appeal memo.
The appeal memo under the
Page 80, my lords, it starts.
Yes.
The first portion is scheduled with legal notice, marked as Exhibit E3, item number 1 and 2, showing the rough sketch as demarked in A1, B1, B, C, so and so, which portion marked with pink lines allowed in favor of the claimants.
Before that, para 25, my lords, the honorable arbitrator.
Property dispute is part of equal parts, in part is 1 and 2. The first and second point of property, which has been clearly demarked rough sketch produced on a
Yes.
Item number 1 and 2 are the second portion of the schedule demarked the sketch A, B, C, D, and E, F, G, E, D, F, G, which portion is marked with green lines is allotted in favor of the response.
Yes.
So my submission, my lord, would be at the most, my lord, the arbitrator could have said, yes, that both parties are entitled to equal share or whatever it is, because it is also my contention to the arbitrator that he has not paid the entire sale. The sale consideration is unequal. He had also suppressed fact. He would say before the learned arbitrator that the entire sale consideration for buying is approximately 1 crore. But I have shown with urgent evidences that it is not just 1 crore, it is 1 crore 71 lakhs. Out of which, my lord, he has paid only about 50 lakhs. And then, my lord, out of the loan which had come, that all was a matter of trial. Out of the money which had, extra money which had been taken. So, my lord, the apportionment of property could not have been 50-50. It could have been a little more in my favor, considering the valuation of the property. My lord, the learned honorable arbitrator, my lord, would repel all those contentions and mechanically say, since you are partners, each of you are entitled to 50, and then this particular property, which is earmarked A, B, C, D, which he too doesn't claim, is given to him. And the other portion is given to me. Agreed by this, my lord, I will confirm the appeal, and I also would produce, may make an endeavor to produce some documents which had a direct bearing, which I could not produce, which my lord was rejected, which I showed to the honorable court.
What are those documents?
My lord, those were all, my lord, I have not produced it here, my lord. These were all documents which clearly showed where we admitted that he had not paid the entire sale consideration. In fact, my lord, may kindly see the order sheet. Order sheet, my lord. This honorable court, in an earlier occasion in 2022, the earlier bench, my lord, clearly said that he had not come out clean before this honorable court while repelling his application for injunction. That also, my lord, operates as a res judicata in the legislative proceedings. The honorable court would also say that in the said order that this honorable bench would say in said order that he has not come out clean before this honorable court as a result of which he had suppressed.
What is the date?
The date of that order is 28/7/22.
28/7/22.
Having heard the learned counsel,
yes.
Having heard the learned counsel for the appellants in the said appeal and the connected appeal, and having perused R1 to R14, most particular R1, a letter addressed to the appellant in the lead appeal, an applicant in IA3 or MFA 165/21 to the bank, it is apparent that the appellant in the lead appeal have not disclosed all the facts with regard to sale consideration paid to the vendors of the land purchased by them. Exhibit R1 clearly demonstrates the admission by the appellant claimants in the lead appeal of sums additionally paid to the vendors over and above the loan amount received by the bank. In that view of the matter, application vacating the IL3/21 in M of is also rejected.
What is Exhibit R1?
R1, Malad, sorry, Malad. R1, yes, only produced now the new easy Malad in Canada.
At page 98, my lords. In English.
I had some difficulty.
Loan facility sanctioned. With regard to the above, we sincerely thank you for the loan facility of 1 crore. We would like to bring to your kind notice that we are getting the property registered on.
My lord, it was his case, my lord, claim that the entire sale consideration of 1 crore, which was reflected in sale deed, was funded out of bank funds. He had paid, but that was not true because this particular seller, my vendor, was a partnership firm, some cotton producers. That particular company had about 15 partners. 15 partners. And my lord, these partners were not on good terms with one another. That is how the property was sold. That is just now passed on to us, probably that litigation. And my lord, we had actually bought off the shares, purchased those shares of sale, and there were and balance 7 people remain. It is that 7 persons who execute sale deed in our favor, for whom, my lord, and the sale consideration was paid partly out of 1 crore which we had taken. So, my lord,
What exactly was the sale consideration according to
it
you?
was 1 crore 71 lakhs. That is not his figure. So, my lord, he has paid only 50 lakhs, which we borrowed. The rest of the money he had not paid. In fact, I arranged for private loans also. In his legal notice, he admits that. I pay that also. So my case before the Honorable Arbitral Tribunal was, my lord, that it is not 50-50. I have to get more because I have to pay that money. Or if you had paid that money earlier, then probably 50. That is not considered. And the Honorable Tribunal would say 50-50 and then to giving him the better portion of the property. In my opinion, my lord, he might say no, it's the value. But my opinion, my lord, it's not. The court could not have done that. The tribunal at the most could have said 50-50 and then left it for us to go work out our remedies by having a commissioner appointed, etc. That's the failure, but it goes to go to the court. So hence, my lord, an appeal before the in section 30. 34, my lord, it would have strengthened our case had an application. My lord, the Honorable Civil Court just rejects it, refuses to exercise this. So that, my lord, is an apparent error, my lord. It's a clear violation of the law of the land, my lord, and the orders have been set aside. Not could I take exhibit A? It says this. With reference, in fact, this Honorable Court, my lord, has seen this and passed that order. So, my lord, I don't think, my lord, it can be interpreted in any other manner. So, my lord, with reference to the above, we sincerely thank you for the loan facility of 1 crore sanctioned to us. We would like to bring to your notice that we are getting the property registered on or before 15th of April 2008. We already drawn the DDs for 9 partners of Shivayogi Cotton Press. That is already we have paid and got their shares transferred in our names. The remaining 7% are also ready to part with their shares. Now we have decided to get the entire property through sale deed. Hence, we have to draw DDs for remaining 7%. Together, all the 16 members will execute sale deed in our favor. This takes place on or before 15th so on the day of registration. So that is how my lord. So he clearly says 1 crore, which is what is sought for, is where the remaining partners and the earlier partners we already paid. So that is how the sale deed reflects only 1 crore.
When you say paid, who pays? The firm pays.
The firm pays, and both of us had to three of us, my lord, form one portion of the firm, and we are there. So we are calling 1 and 2. And my lord, payments are also being proved by production of account statement, which is also not denied. Now, my lord, all this respondents are. Now, my lord, may kindly come to the claim section. Take some time, my lord. He says, it is submitted to the claimants and the respondents will be mutually desirous of entering into the business together, agree to enter into a partnership with the business of real estate. By way of partnership deed dated 22/5/2007, the claimant and respondent constitute a partnership at will in the name and style of Guru Muraleshwara Swami Associates. Apart from others, the said partnership firm partnership deed also declares the profit or loss of firm or so. It is submitted under sale dated 15/4/2008. The said firm had purchased of immobile property presently bearing Davangere, Manarapalike, so and so. Davangere here referred to scheduled property. A copy of sale is produced. 7th paragraph. It is submitted.
No,
by
6th para is important, Manoj. I'm sorry.
6th. It is submitted apart from the purchase of the said property, the firm has not been engaged in any other business or activity. It is submitted. It is submitted the entire sale consideration was met through a loan. I didn't want to waste time with court. That is why I jumped that paragraph. Now that is the 6th. It is submitted the entire sale consideration was met through a loan of 1 crore obtained from Davangere Harihara Urban Cooperative Bank on 12/4. Well, this is false. In fact, exhibit R1 itself clearly states it is not just this 1 crore rupees which is part of the sale consideration, but something more. The said property is mortgage in favor of the bank. It is submitted the entire amount of 49,48,807 to a principal payable agreement. Copies of it. He says before the honorable tribunal that he paid 50 lakhs and I paid 50, so I'm entitled. It is submitted the firm has not done any business, etc. And then legal notice speaks about the production of loans, and at paragraph 12, he says that the legal notices were also issued. It is submitted to the legal. Davangere Harihara, this is important. Sarkara Bank Niyamita had issued a notice dated 17/4/2017, and the firm and its partners have jointly borrowed sum of 70 lakhs as secured cash credit on 31/3/2015. The said loan is fully secured by mortgaging of assets at the time of bearing of loan. That there is liability of 50 lakhs 193 on the principal and 809,804 on the interest. A copy of notice dated 17/4/2017 is produced on document number 9. Despite receipt of this, respondents have neither paid their share of the amount and release the liability nor communicated with the claimant. The respondents are solely liable to pay the sum. If the claimant suspect the respondents are concerned to deprive the claimants of the share of the property. Then, my lord, prayer. Seeking for equal division in terms of the legal notice. Now, my lord, can I take my lord to the legal notice issue? The legal notice, my lord, is at 63. Is at, my lord, marked exhibit 53, at page 53, exhibit 63. Since I marked in my this one, I would
It is at 63, my lords.
Then I will see it. But in my
Today's paper.
63.
Please.
He had the benefit of cutting and making notes, whereas I would have done on the basis of older. You are aware that my clients entered into partnership with clauses. The name and sale of Guru Muralideshwar Swami Associates by partnership deed dated 22/5/2007. The main business of firm was real estate, acting as developers and business. You are aware that except purchasing property bearing Davangere so under a sale deed dated 15/4/2008, the aforesaid firm has not done any business. The firm has no other assets apart from the said firm. You are aware the firm has borrowed 1 crore from the Davangere Harihara Urban Cooperative Bank Limited, Davangere, and the deed of mortgage in 25/4/2008. You are also aware that our clients alone has paid a sum of 30 lakhs for repayment of sum to the Davangere Harihara Urban Cooperative Bank, Davangere. Next part is very important. My client also wished to say that the first of my client had borrowed a sum of rupees 20 lakhs from Dayananda and rupees 10 lakhs from Panchana. He had given blank checks to the aforesaid persons in lieu of repayment. However, he was shocked to note that the aforesaid persons that the first of you, Virupakshappa, that the appellant therein, has falsely informed that I had sent the entire amount towards repayment and taken back the blank checks. But it is like this. Though I do not want to prejudice the mind of the court, but this respondents are not politicians. They are not constructive. But I use my good office since there is a shortage of money, and I said that I will, on my assurance, please lend 30 lakhs. So 2 persons gave 30 lakhs. They also took blank checks. My lord, the repayment was not happening. As it was envisaged, politicians don't repay. I was under pressure because I had agreed to be a sort of unofficial guarantee. And my lord, I go and pay them. So I said that, look, Then he gave me the money, he had not given. So to his shock, he says, I repay that 30 lakhs, my lord, and then I take back the checks, it is with me. Now it's become stable. So, my lord, apart from the entire sale consideration, I also paid this 30 lakhs. Now, my lord, 30 lakhs was what was actually initially paid to those partners who were having problems and were to be settled down. So, my lord, that has not been accounted for. It's a clear admission by him itself. My lord, he would try to wriggle out of this particular admission in his petition by stating that it was due to inadvertence, by oversight, it is some other transaction. When he himself says it's more than business transaction, I fail to understand, my lord, that how it can be some other transaction, nothing to do. So, my lord, this has not been appointed, clear-cut admission, my lord. Then, my lord, the Honorable Tribunal, my lord, now, my lord, I will also come to the legal notice issued by, I'll come to the partnership deed, my lord, at Exhibit E1, and it is produced at page 26 of the new.
Yes.
At page 34, it speaks about arbitration. That in case of dispute arising on the interpretation of same shall be referred to arbitration of one or more partners, arbitrators, and the decision of the arbitration shall be binding. Now, my submission, my lord, would be the dispute as a stage as far as division of property, etc., might not come. That is, my lord, for a moment, as you concede, I concede that it is so. My lord, may kindly see the legal notice, which I read. No, my lord, the legal notice.
Page 63.
My lord, kindly see what is sought in the legal notice at page 67. He gives many suggestions, divide the portion under so and so. But finally, my lord, if you don't excise either of the options and enter into a settlement agreement under section 73 of the arbitration, it is now amended. It is deleted under the finance act. Within 15 days from the date of receipt of the notice, my client will invoke the arbitration clause and seek for appointment sole arbitrator to the arbitration of Karnataka, eligible race to so in terms of arbitration. My lord, this was not a notice, my lord, contemplating the appointment of arbitration. It doesn't go for conciliation at all. My lord, and then immediately thereafter, instead of referring for a conciliation, my lord, the petition under section 11 is filed and allowed. And then the arbitrator, my lord, will pass the order which I showed, my lord, wherein division of property is done, not on what he asked for. Now, even the honorable arbitrator at the most could have, my lord, said that I will entitled to 50-50. Let us assume disallowing all my claims and not disallowing all my claims, could not have partitioned the property, which, my lord, could have been the domain of a civil court, because, my lord, the honorable civil courts, my lord, what they would do when dividing a property, even among family members, will either see whether it can be bought by one party, value the property, if not, whether it can be jointly sold, etc. That endeavor is not blindly just dividing the in Bangalore property down just on the basis of stakes, furnished by him. My lord, this goes to go to the matter, and my lord, the arbitral award should have been. And my lord, I showed to the this honorable court, my lord, in appeal. The honorable court refuses to accept it. The honorable Supreme Court judgment, my lord, is very point, my lord, that when it is for the tribunal to either allow or not, probably it might not have allowed. I also concede, might have not have allowed. But the very fact, my lord, that stating that CTC itself is not applicable is actually an error of jurisdiction. So, my lord, this is what I would want to say. I do not want to burden much on because of the evidence, etc. The short point is only this. Yes, my lord, I pray that my matter be admitted. My lord, it has to be closed for hearing in details.
Not hearing in detail. No? He has argued on it.
I'm taking submissions, sir.
We are hearing in detail. Yes.
My lords, may kindly turn to page 26, my lord, partnership deed. It's a registered firm. Is the deed entered into on 22nd May 2007.
Yes.
26. Two clauses I want to rely upon. My lords, may kindly turn to page 733, internal page 8, my lords.
Yes.
Clause 8. the distribution, the profit or loss of the firm after interest and remuneration shall be equally distributed among the partners. Then kindly see the next thing, my lords, 9. Accounts of the firm shall be closed on 31st of March of every year. No, my lords, after 2008 purchase of the property, the firm has not filed any returns, my lords, except the sale deed. No other document can be looked into with the matter. They rely upon exhibit R2 to R10, my lord, to show excess payments were made, and R1. My lords, all that are before the sale deed, my lords. Sale deed is 15/4/2008. My lords may reckon the date. All those documents are 8/4/2008, my lords, earlier to sale deed. Sale deed says 1 crore was paid, it was borrowed from the bank. That's a conclusive, my lords. Arbitrator by a detailed award has held that sale deed prevails, and he has not demonstrated that any excess amount was paid. My lords, in the claim petition, only one statement I want to show. Your lordship may kindly turn to page 5 of the claim petition. It's in the same paper book, my lords.
Yes.
In so far as that statement that Dayanand and Penchanna at para 11, my lords, I have clarified. It is submitted and made clear by the claimants that apart from the sum of 1 crore borrowed from the aforesaid bank, neither of the parties have contributed any additional monies for purchase of the property or the capital of the firm, except for stamp duty and registration fees. The claimants clarify, I was the claimant there, my lords, that the transaction is so and so, mentioned in the legal notice dated 7/10/2020 as also CMP number so and so, has nothing to do with the firm. The same is by inadvertence. Thereafterwards, they have not let in any evidence to clarify that the said sum was part of the firm's accounts. Now, the initially in the CMP, a civil judge was appointed to go into the arbitration matter, arbitration center. They made allegations against him. He resigned. I had to move the matter before this court again. They did not raise any objection regarding jurisdiction, my lords. First time before this court, they are raising this objection regarding appointment of the arbitrator. This court was constrained to appoint a retired Supreme Court judge as the arbitrator in the matter, and he has passed the award. That award was challenged. Two things I want to demonstrate. Regarding the firm's account, my lords, your lordship may kindly take the Partnership Act, my lords, two provisions of law. Accounting, how it has to be distributed. Section 48. Act is very clear. Mode of settlement of accounts, my lords. Yes. In settling the accounts of a firm after dissolution, the following rules shall subject to agreement by the partners be observed. A. Losses including deficiencies of capital should be paid first out of the profits, next out of the capital, and lastly, if necessary, by the partners individually in the proportion in which they were entitled to share profits. That is, the bank loan was there, and the arbitrator has given a finding that I had paid 48 lakhs towards the principal and 96 lakhs towards the interest. And this amount of 51 lakhs he had to pay, and 50 lakhs he had to pay. Arbitrator has passed that award. Arbitrator has also held that in execution proceedings, if I want to initiate for division, that I have to pay the remaining 1 lakh and odd toward my share of the principal, and he has to pay 50 lakhs. That 50 lakhs I have paid and put into execution 4 years back, my lords. Now I am not able to execute because of the interim order passed by this court. Kindly see the next B, 48B. The assets of the firm, including any sums contributed by the partners to make up the deficiencies of capital, will be applied in the following manner and order. Your lordship may kindly skip to Roman 4, my lords. The residue, if any, shall be divided among the partners in the proportions in which they were entitled to share profits. That's all, my lords. My lords, two judgments on that division can be made by the arbitrator. Before that, only one judgment of the Honorable Supreme Court regarding interference of the award. This stands even as on today, 2015, Navodaya Mass Entertainment, my lords. Your lordship may kindly see paragraph number 7. When an award can be interfered at.
Yes.
We have perused.
clarified all those issues. Because they were divergent views.
No, that is regarding modification. I'll produce the judgment also. We have perused the order, para 7, my lords. We have perused the order passed by the division bench of the High Court. We have also heard the learned counsel for the parties. The learned counsel appearing on behalf of the appellant submitted the arbitrator in the courts. I failed to appreciate the fact that claim was not on a revenue sharing basis, that is the gross income, but it was on the basis of minimum guaranteed amount stated in the petitions. The learned counsel appearing on behalf of the appellant tried to argue before us that alleged agreement was not legal, valid and enforceable. He further submitted same was a one-sided agreement. He also submitted that the division bench of the High Court ignored and overlooked clause 14 of the agreement, which deals with the termination of the agreement by the conduct of the parties. We are afraid that such points, as has been tried to be contended before us, it appears was never heard before the learned single judge or before division bench of the High Court. The dispute between the parties has been adjudicated upon by the arbitrator. Award has been published. The division bench of the High Court has found that award cannot be said to be perverse or that there is no cogent reason to set as the same. In our opinion, the scope of interference of the court is very limited. The court would not be justified in reappraising the material and record and substituting its own view in place of the arbitrator's view. Where there is an error apparent on the face of the record, the arbitrator has not followed the statutory legal position. Then and then only it could be justified in interfering with the award published by the arbitrator. When the arbitrator has applied his mind to the matter before him, the court cannot reappraise the matter as if it is for an appeal, and even if two views are possible, the view taken by the arbitrator would prevail. Then they had we have para 9, my lords. We have also perused the clauses of the said agreement, in particular clauses 3 and 5 of the agreement. We find that the reasoning given by the division bench of the High Court cannot be said to be perverse. Furthermore, the appellant never terminated the agreement or requested the first respondent to take back the machinery. Now, at this stage, it would not be proper for us to express further opinion in matter when the matter dispute has already been concluded by the arbitrator. Award has been affirmed by the High Court. My lords, regarding that 34, section 34 appeal, no application satisfying the requirements of 34 this 4 was filed seeking for further evidence, madam. No application satisfying the requirement. The appellate court has clearly held that it doesn't satisfy the requirement of law. Only one this appellate court has modified the regarding this partnership. This one can be divided. I'll pass on a judgment of the Honorable Supreme Court, my lords. It can be the power of the arbitrator. My lords, may kindly turn to para 8, my lords. What is the nature of the property brought by the firm? The above provisions make it clear that regardless of the character of the property brought in by the partners and the constitution of the partnership firm, or that which is acquired in the course of the business of the partnership, such property shall become the property of the firm, and an individual partner shall only be entitled to share of profits, if any, accruing to the partnership from the realization of this property, and upon dissolution of the partnership to a share in the money representing the value of the property. It is well settled that firm is not a legal entity. It has no legal existence. It is merely a compendious name, and hence the partnership property would vest in all the partners of the firm. Accordingly, each and every partner of the firm would have an interest in the property or asset of the firm, but during its subsistence, no partner can deal with any portion of the property as belonging to him, nor can he assign his interest in any specific item thereof to anyone. By virtue of the implied authority conferred as agent of the firm, his action would bind the firm if it is done to carry on in the usual way the business of the kind carried by the firm. But the act or instrument by which the firm is sought to be bound must be done or executed in the firm name or in any other manner, expressing or implying as in intention to bind the firm. His right is merely to obtain such profits, if any, as may fall to his share, upon the dissolution of the firm, which remain after satisfying the liability set out in various subclasses 1 to 4 of clause B of section 48. That I read. My lords, may kindly skip to paragraph 16. From the foregoing discussion, it seems clear to us that regardless of its character, that a property bought into stock of the firm or acquired by the firm during its subsidies for the purpose and in the course of the business of the firm shall constitute the property of the firm unless the contract between the partners provide otherwise. On dissolution of the firm, each partner becomes entitled to a share in the profits, if any, after the accounts are settled in accordance with Section 48 of the Partnership Act. Thus, in the entire asset of the firm, all partners have an interest, albeit in proportion to their share, and the residue, if any, after the settlement of accounts and dissolution, would have to be divided among the partners in the same proportion in which they were entitled to a share in the profit. Thus, during the subsistence of the firm, a partnership partner would be entitled to a share in the profits, and after its dissolution to a share in the residue, if any, on settlement of accounts. The mode of settlement of accounts set out in Section 48 clearly indicate that partnership asset in its entirety must be converted into money, and from the pool of disbursement has to be made as set out in Clause A and subclause 1, 2, and 3 of Clause B, and thereafter, if there is any residue, that is to be divided among the partners in the proportion to which they were entitled to share in the profits of the firm. So viewed, it becomes obvious that residue would, in the eye of law, be immovable property, that is, and distribution of the residue among the partners in proportion to the shares in the profits would not attract Section 17 of the Registration Act. Viewed from any other angle, it must be realized that since a partnership is not a legal entity, but is only a competitor's name, each and every partner has a beneficial interest in the property of the firm, even though he cannot lay a claim on any earmarked portion thereof, as the same cannot be predicated. Therefore, when a property is allocated to him from the residue, it cannot be said that he had only a definite limited interest in that property, and that there is a transfer of the remaining interest in his favor within the meaning of Section 17 of the Registration Act. Each and every partner of a firm has an undefined interest in each and every property of the firm, and it is not possible to say, unless the accounts are settled and the residue or surplus determined, what would be the extent of the interest of each partner in the property. It would, however, clear that since no partner claim a definite or earmarked interest in one or all the properties of the firm, because the interest is a fluctuating one depending on various factors, such as losses incurred by the firm, the advances made by the partners as distinguished from the capital brought in the firm, it cannot be said unless the accounts are settled. The manner indicated by Section 48 of the Partnership Act, what would be the residue which would ultimately be allowable to the partners. In that residue, which becomes divisible among partners, every partner has an interest, and when a particular property is allocated to a partner in proportion to his share in the profits of the firm, there is no partition or transfer taking place, nor there is any extinguishment of interest of other partners in the allocated property, in the sense of a transfer or extinguishment of interest under Section 17 of the Registration Act. There, so and so. Then your Lordship may kindly come to last 4 sentences. The same thing they have reiterated. I will not read that, my lords. Kindly see page 607, my lords. Placidum G, my lords. 5 lines from below. The award read as a whole, it starts. Yes. The award read as a whole makes it abundantly clear that arbitrators had confined themselves to the properties belonging to the 2 firms and had scrupulously avoided other properties in regard to which they did not reach the conclusion that they belong to the firm. On a correct reading of the award, we are satisfied that the award seeks to distribute the residue after settlement of accounts on dissolution. While distributing the residue, the arbitrators allocated the properties to the partners and showed them in the schedules appended to the award. Same thing the arbitrator has done in this matter. We are therefore of the opinion that on a true reading of the award as a whole, there is no doubt that it essentially deals with the distribution of the surplus properties belonging to dissolved firms. The award therefore did not require registration, and when they were dealing with that, they had dealt with this also. One more judgment. In similar lines, my lords, I will read only one paragraph in that judgment. Later judgment of the Supreme Court, which follows the earlier judgment. Your Lordship may kindly turn to para 3, my lords. We have carefully perused the award in question. By the award, the arbitrators have distributed the assets of the dissolved firm between the partners in accordance with their respective shares in the partnership. The real question for consideration is whether such an award amounts to a creation of or transfer of any fresh rights in immovable or immovable properties, so as to bring it within the ambit of Section 17 of the Registration Act. A perusal of the award shows that it's simply a case of distribution of the assets of the dissolved firm amongst the partners themselves. A partnership firm is not an independent legal entity. The partners are the real owners of the assets of the partnership firm. Actually, the firm name is only a competitor's name given to the partnership for the sake of convenience. The assets of the partnership belong to and are owned by the partners of the firm. So long as the partnership continues, each partner is interested in all the assets of the firm, as each partner is owner of the assets to the extent of his share in the partnership. On distribution On dissolution of the partnership firm, accounts are settled amongst the partners and assets of the partners are distributed amongst the partners as per the respective shares in the partnership firm. Thus, on dissolution of a partnership firm, the allotment of assets to individual partners is not a case of transfer of any assets of the firm. The assets which herein before belong to each partner will after dissolution of the stand allotted to the partners individually. There is no transfer or assignment of ownership in any of the assets. This is the legal consequence of distribution of assets on dissolution of the partnership firm. I'm sorry. I leave it at that. Your Lordship, may only one more judgment when a sketch is shown by the arbitrator. That also Supreme Court has dealt with that matter. Only one paragraph in that judgment. Latest when the sketch is referred. It is for easy reference. The Supreme Court has commended the courts for having shown the sketch. 2018 6 SCC 443. Your Lordship may kindly turn to para 2. The appeal filed by the plaintiff challenging this decree was dismissed by the High Court on 5/11/2003. The defendant filed an application before the trial court in said case for amendment of the decree, directing the sketch map submitted by the plaintiff on 6/2/2001 to be marked as an exhibit and part of the judgment and decree by effecting necessary corrections in order to make the decree executable. The trial court, by order dated so and so, allowed the said applications as under. Ordered that the petition dated filed by the defendants is hereby allowed on consent, but without cost. Let the sketch map submitted by the plaintiff along with this petition dated so and so be made part of the judgment and decree. Judgment and decree be amended accordingly. The plaintiff challenged the said order before the High Court of Calcutta. The High Court, by its order dated, has allowed the revision set aside the order dated of the trial court during the pendency of these proceedings so and so. I will not read that. My lords may kindly skip to para 5. No, I am not on that. Sketch easy reference. Para 5, my lords. Para 5, my lords. We have carefully considered the submissions of the learned counsel appearing for the parties. There is no dispute as to share allotted by the trial court in favor of the parties. The plaintiff allotted 3/5 share and the defendant was allotted 2/5 share in the suit scheduled property. It is clear that the sketch map relied on by the trial court was produced by the plaintiff showing the frontal A lot property containing his 3/5 share delineated with yellow border and B lot property showing defendant's 2/5 share delineated with red border. The application filed by the plaintiff producing the aforesaid reads as allowed. Then kindly see it, skip to para 6, my lords. It is clear that the plaintiff had also produced 2 other maps on so and so, that the plaintiff had sought partition of the said truth property in terms of the plan produced on 6/2/2011, which is evident from the application referred above. As such, plaintiff cannot be permitted to say that the map produced with application was not the map filed by him. It is not possible to give effect to the partition decree without a sketch map of the suit schedule property. At the time of passing the judgment and decree, the trial court should have made the said map as part of the decree so that the partition could have been effected as per the said sketch. No party should be allowed to suffer for the error of the court in the circumstances. The trial court has rightly made the plan as part of the decree for effecting partition. We are of the view that High Court was not justified in setting aside the said order. Hence, this appeal is allowed so and so. My lords, I will leave it at that only. In the second matter, the trial court has modified the award, my lords, by one paragraph. The lordship may permit me to read the award in so far as that.
Was harping upon my lord that profit or loss in the firm of the. My lord may kindly see issue number at page 21 of the judgment, issue number 6. The claimants have placed.
Ada number?
22 of the award.
Award.
Appeal memo. Appeal memo. It is in the appeal memo, my lords.
Page number?
104. My lord, is the appeal memo, but paragraph is 22. Issue number 5 of this code as 6.
Yes.
This issue number 5 has to be, actually 6. Issue number 5 has to be answered against the claimant for the following reasons. Next, the claimants have placed strong lines in support of the case under clause 8 of the partition deed, which reads, well, all these arguments were not based on this. The profit or loss of the firm of interest representation shall be equally distributed among the parties. By clear reading of the aforesaid clause of Partition 3, it makes very clear that the profit or loss which will be earned by the firm has to be equally distributed among partners after adjusting toward interest and remuneration to be paid to employees, and that does not mean that after dissolution of the partnership firm, time given by the respondent by the claimant for settlement as proposed the legal notice and rough sketch marked exhibit BP to divide the property equally as indicated in the rough sketch. The contention of the claimant, the respondents in the reply notice had taken untenable stand and did not come forward for settlement dispute between the parties, and therefore they entitled for the amount as claimed by them in their column. The claimants have pleaded in the plain petition that they suffered loss as they could not dispose the share of the property for which they are entitled to. After disposal of the property, the firm had it is stated by the claimant that on account of untenable stand taken to respondent, the share of the claimant's property could not be sold as divided by them in the legal notice dated 7/10/2023. The claim has been to the claimant in paragraph 14 of the claim portion, market value sold. So, then the share of the claimant's property and interest on the said sum. Then we will not go to the criminal further say the claimants have placed strong claims in support of the claimants strong claims for the cross-aid apartment deal, which is wholly untenable in law. The case ought to be made by them in justification of a claim cannot be accepted by the tribunal, and they are not entitled to set amount. So, my lord, there is a clear finding as far as what my learned friend argued now, which my lord has attained finality because the respondent did not challenge it under section 34 or before this court, my lord. He has accepted that finding against him. So, my lord, all the judgments which my learned friend relied upon probably would have helped. Probably it would have been set right, set that in order, had this issue been against me. Now, my lord, he would rely upon this clause.
This is with regard to laws as they could not dispose of their share in the property for which
So
they
he
are
says, because of my non-cooperation, I did not come forward under that section 73, which is now repealed, my lord. I did not agree for partition, etc. He lost money, and finally, my lord, because of all these losses incurred due to my illegal actions, what remained was this, and so he But my lord, my argument is completely different. I have paid more for this property, so I am entitled to a larger share in the property and not 50-50. So, my lord, this particular argument of my learned friend, my lord, has been rejected. The court says he cannot rely upon this. He cannot go on. The Partition Act is right, my lord. But there is a finding against it. Right or wrong, my lord, there is a finding which has attained finality. He has not challenged. Now, my lord, I will only take one more minute, my lord. I will just stop it. My lord, may kindly see.
We'll anyway have to continue because after lunch this has to continue.
I make one suggestion. Serial number 3. The afternoon some income is some other day. When is there? Some other day.
Serial number 18.
ಯಾವ ಆಗ್ತಿದೆ? July 1st ಬೇಕಂತ ಹೇಳಿ.
Serial number 18 tomorrow.
Serial
number 9, IU extension.
18 next week.
9. Extension date.
Madam, 18 entry ಮಾಡ್ರಿಲ್ಲ.
He was arguing with the 1 minute before anyway.
Wait, 18.
Ma'am, 9 extension.
Madam, 18. 18 1 week. 18. ಸೀನಿಯರ್ ಇಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿಸಿದೆ ಬೆಳಗ್ಗೆ ಸೀನಿಯರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಮೇಡಮ್ ಯಾವ್ದು ನಡೆದಿದ್ದು ಸೀರಿಯಲ್
ಮೇಡಮ್ 5 ಅಂತ ತೋರಿಸ್ತಿದೆ. 5 ಓಕೆ.
Court officer, madam. Madam, 66 adjourn ಆಯ್ತಾ madam? Okay, madam.
Hmm.
Kindly see issue number 6, my lord, sir. Page 16 of the paper book. I find today. Also, in that also it is there. Kindly turn to page 16 of the paper book. Issue number 6, nothing to do with that. Let the claimants prove that they are entitled to 80% interest on both through meeting tax fees, market value of the share of 2% that's all my answer is nothing to do with the main part of the class. So far as the second matter is concerned,
What is the second matter? That is by you, your appeal.
so far as modification of the award, only I read the award, the orders.
Hmm.
The logic is kindly turn to page 14, it's page 14. Skip to para 36. Page para 32, page 46.
Stop. Page 46.
Please, para 32. See what the period was does. Only the remaining provision of law under which the arbitral award can be suspended in section 2B, 2 of the Arbitration and Conciliation Act 1996. That is clause. Arbitral award can be suspended if it is according to the policy of public policy of India. Kindly note this, my lords, at the time of argument, relevant counsel for the respondent has not stated that how this case comes under the purview of public policy. After holding that, the learned judge goes on to modify the award. Even then, it is the bounden duty of the court to verify whether the award passed to the arbitral tribunal is violating of any fundamental policy or not to decide whether the award to be set aside. Then you will actually kindly skip to para 36 at page 52, my lords. Because the other side not bringing it within the public policy, the German district judge goes on para 36. In this background, the contentions of both parties before arbitration are solved. Page 46, and then 36 and page 58. 33. The learned says the time of arguments, learned counsel for respondents are not stated that how this case comes under the purview of public policy. Here after she goes, judge goes on at 36 and page 52. 36 and page 52 the appeal memo. With this background, with this background, page 52.
Yes.
With this background, the contentions of both parties before arbitral tribunal will be to decide whether arbitral tribunal is against any public policy of India or not. Then you will also be kindly come to para 54 minutes. So far as this modification is concerned. At page 65.
Hmm.
In the legal notice, as per exhibit R3, the claimants are given two options to the respondent to divide the property into two equal shares. To repay the entire loan to the bank and both parties will not pay reimbursement to the bank by claimants and to Karnataka and so on so the respondents. This shows that the transaction is so and so is pertaining to purchase of the suit property. And such an unequal admission is made before the arbitral tribunal because not open for the claimant to say in the claim petition that they have stated so in legal notice inadvertently. As per section 18 of the Evidence Act, a statement made in the legal notice of behalf of the claimant amounts to an admission. Hence, do not go by the admissions. The claimants have produced document before arbitral tribunal to show that they have repaid the loan amount. Exhibit P9 shows that on as on 26/3/2018, the partition note has repaid 94 lakhs for its interest. And outstanding principal balance amount is 50 lakhs, 51,000 with interest of 16 lakhs for the 31 feet. Under these circumstances, when the claimant themselves are given the order of waiver of repayment of money to the bank, it is said to, it is to be held that both parties are to be directed to pay the balance loan amount, including the principal and interest to the bank equally, and both parties to be directed to divide the property equally. Because there is no proof produced to the payment that they have repaid the loan amount of so and so, or the payments are not brought these facts to the arbitral tribunal in a non-fictitious manner. They have put forth only their cases and execute to validate all the witnesses before the arbitral tribunal. Resulted in passing of the above order, directing any respondents to pay the balance loan amount of interest. Hence, that much modification in the arbitral amount is required. Then you are also trying to come to paragraph 58 and 58. The above discussion relates with the payments of arbitration of taking loan. Its reimbursement to the respondents made the award against public policy. The arbitral tribunal discussed about taking loan and so on. As discussed earlier in so and so, their lordships clearly held that fundamental policy Indian law included all such fundamental principles as providing a basis for administration of enforcement of laws in the country. In this case also, payments are not brought to the notice of the arbitral tribunal of loan of so and so, and the district arbitral tribunal which resulted in this fact can be considered as against fundamental policy of India. Hence only that modification is required in the award. Now, after that, you are also kindly turn to para 61. Well, also, passing here for a moment, the legal notice was never accepted by them. My terms that we divided it equally was never accepted by them. There was no question of me suppressing anything from the tribunal. All these were there before the tribunal. Tribunal has dealt with this matter regarding this terms. Kindly see para 61. The above discussion during that this court is not reappreciating the evidence of record is not substantive. Suppression of some fact to the payment. Totally unwanted. It was not correct. The logic for arbitral tribunal. This modification in the award is required. The above is really not the payments. The logic may kindly skip to para 68 in this context. Page 73.
Yes.
For other reasons, this court holds that a small modification is required in the third paragraph of the operating portion of the award. When claimants themselves are given of their claim of payment to a person or own and it is obligated owners. Directing respondents to pay their share of the proportionate interest due to countries incorrect. Modification in the award at that point is required. Both parties are directed to equally repay the balance of outstanding loan amount to the Karnataka heir of uncooperative bank. As on the date of claim petition, that is not correct, my lords. The one was due to the bank that higher court, the appellate court was not right in passing this, modifying this award. Then at the modification is at page 75, paragraph 3 of the order. 75.
Yes.
Paragraph 3 in the operating portion of the award is necessary. Last place. And in that place, the modified paragraph is inserted as follows. Both claimants and respondents are directed to equally repay the balance outstanding of the document as on the date of filing of the claim petition. So this was not the case of the respondents, the appellant before the Supreme Court, nor the case of the parties. The trial court on its own, which straight away goes for modification.
Your contention was that you had repaid your half of the amount as well as the interest on that.
By virtue of the award, when you see the award, the arbitrator, only one paragraph issue.
Yes.
When you see that part of the issue, the also we get it at page 106, paragraph 23. Where does it appeal the moment?
106.
Appeal the moment. Issue number 6 is corrected as issue number 5 at page 106.
Just a moment. Just a moment.
Will make the things clear.
Yes.
It is clear that the claimants in the claim petition and also shown to the fact with the evidence of everyone that out of their share of liability of 50 lakhs and proportionate interest amount of the bank. The loan amount of $1 crore to the partnership bank is required to be remitted to the parties. It is also pleaded by the claimant that they are a sum of 49 lakhs towards the principal and 94 lakhs towards interest to the bank as their share of liability of the aforesaid borrowed amount. To substantiate the above plea, the first claimant is exempted as legal woman in this case, specifically stated in some evidence clarified that the claimant claimants are limited to set amount of their share of directly to the bank estate was sworn to the affidavit of feudal and same is neither controverted by the respondent counsel nor are denied in the evidence affidavit of respondent number 1. Further, the claimants are also produced documentary evidence of the PA that will prove the said fact. The correctness of thing is not disputed with the respondent senior counsel for causing information of feudal 1. Therefore, this tribunal has to accept the case of the claimants as reducing evidence on record. The claimants have to admit if any shortfall in their share of liability of 50 lakhs. The proposed interest after adjusting the payment made to the client as per Exhibit P8 and P9. Accordingly, issue number 6 is answered in the affirmative. Tribunal has noted that I have already paid 49 lakhs, so remaining sum I have to pay. For executing, your also will kindly see paragraph number at page 108, the award starts.
108.
108 minutes. Roman 3, first paragraph that the tribunal has divided the properties.
Yes, award.
The respondent at page 108. The respondents are required to repay the share of the debt along with proportionate interest which amount is respondent claiming as equivalent in the before this court. So also claiming we have to limit of their share of future debt after deducting the amounts already paid of their share to bank as within PA 89. Both the parties have cleared the loan amount to the bank within 6 months after the property discharged by obtaining the producer from the bank. Facilitate them to get the respective of the property as allotted in their favor in this operative portion of this award. For proper understanding and clarity of the definite shares established by the respective parties in this case. The subsequent challenge to exhibit PC is able to along with this award. It is also that it is also open for either of the parties to dispute this award to get their respective share. If either of the parties does not give notice of as mentioned in this award by paying the balance amount with proportionate interest due to the out of the loan amount of 1 crore after deducting the payment which is already made to the claimant towards and interest on. That I can go for exhibition. So I deposited 50 lakhs at both exhibition. That is not disputed by them. I deposited it. Now, in so far as this modification, the latest judgment of the Arbitral Supreme Court.
Yes.
Regarding modification. Supreme Court. Portion of the judgment of the Arbitral Supreme Court is modifications. We have permitted modification only under certain very limited circumstances.
Yes.
You are also kindly turn to paragraph number 3. The fulcrum of the legal controversy raises the following question. Are Indian courts jurisdictionally empowered to modify an arbitral award? If so, to what extent? That I will come to the offensive portion first, then I come back to the analysis at para 85. Conclusion, last page. Last but
Yes.
accordingly, the questions of law referred to by so are answered by stating that the court has a limited power under section 34 of the 96 Act to modify the arbitral award. This limited power may be exercised under the following circumstances. When the award is severable by severing the invalid portion from the valid portion of the award as stated in part 2 of our analysis. I took the part 2 because Roman 2, 3 and 4 are not applicable to our practice. Article 142 Supreme Court has the power. Then correcting clerical errors. This is not a clerical error. One is applicable. I consequently permit me to read analysis. That is at paragraph 24. The court has said it is as per the analysis in the conclusion. When the award is severable, as reading 85(1), when the award is severable by severing the invalid portion from the valid portion of the award as held in part of our analysis. Let me come to paragraph 24. Paragraph 24, first paragraph. 24. Analysis starts at paragraph 24. Given this background, we have to determine whether under what circumstances the courts have the power to modify very arbitral awards. So also we kindly skip to part 2, that is what the Supreme Court is paragraph 24 onwards. In the present controversy, the proviso to section 34 2A4 is particularly relevant. It states that if the decisions are matters submitted to from those not submitted, only that part of the arbitration law which contains decision on matters non-submitted may be set aside. The proviso therefore permits court to see that non-arbitral portion from the arbitral demands. This serves a two-fold purpose. First, aligns with section 60 of the conforms with principle of social. That is, the arbitrator's competence to determine their own jurisdiction. Secondly, it enables the court to resolve the valid parts of the order, setting aside invalid ones. Indeed, before the set of the parties are valid, the court is not empowered to undertake such a segregation. But also, we kindly skip to analysis at para 45 minutes. We are thus of the opinion that section 34 court can apply the doctrine of severability and modify the portion of the award while retaining the rest. This is subject to parts of the award being severable, even in particular stipulated part of the also are observed that an order varying an award is not equivalent to an appellate process. The author suggests that a modification order is only be appropriate where the modification including the adjustment of costs follows inevitably from the tribunal. This approach would be beneficial as it would reduce costs and delays. The courts need not engage in any fact-finding exercise by acknowledging the court power to modify awards. The judiciary is not erasing the statute. We hold that the power of judicial review under section 34. The side of an award should be read as inherently including a limited power to modify the award within the constraints of section 34. We are kindly come to para 49. Notwithstanding section 33, we affirm that the court reviewing an award under section 34 possesses the authority to execute computational, clerical, and technical errors as well as other manifest errors. Only that much, my lords, manifest error, provided that such modification does not necessitate merits-based evaluation. There are certain powers inherent to the court, even when not extremely strictly granted to the legislature. The scope of this inherent power depends on the nature of it pertains to appellate reference or complete jurisdiction as in the case of section 30. Powers are intrinsically connected as they are not in parts of the jurisdiction exercised by the court.
Yes.
That's all. That is the only part. Para 49 they have settled the issue, and in the conclusion, para 85 they say it is as per para.
The doctrine of implied power is only to effectuate and advance the object of legislation. That is the 96 Act, and to avoid hardship. Therefore,
49 is the only grounds where manifest error. There is no manifest error for the trial court. Both of us have to repay the loan equally. Therefore, trial court should not have manifest saying, I have already paid the amount substantial amount. It says from the date of claim petition, I will be prejudiced by that part. Not have been carried out by the claim. It's a concurrent finding on all tracks. There is no errors there. The court has followed that. I pray for dismissal of this appeal and my appeal.
what were the documents that were sought to be produced before the court?
It is only the 6 minutes. That was not before the tribunal. That application by conductor did not even go through the application that he had filed. If there was any merit, he would have brought the notice of the court. These were the documents we had to file. And even then, there are some exhibit R2 to R10. They say that excess amounts are paid under that. Part of the amount I have paid under that. The respondents are paid. I demonstrate they are referring to R2 to R10. For academic purpose, can you turn to page 100? Eight copy are produced. R2 to R10. R2, typed copy is at page 102. It's a translated copy. R2, he says in evidence, he says R2 to R10 is the payment for 71 lakhs. That the arbitral tribunal has negative. When we see this is in favor of the respondent, this payment receipt is written in executed of this deed, they have certificate 2008, that is before the sale deed, 10 days, 4 months before the sale deed, by so and so, by so and so, respect, is there, M. Veerabhadrappa, he is the first respondent before this honorable court. So the payment receipt is in my favor, R3 receipts, R2, R3, at page, is in my wife's name, page 107.
This is page 103 says it is for as partner.
Purchaser of the land has given this receipt. That is in my favor. Even if that, assuming that the excess payment, I have made the payment. Part of the payment. I will just give the figure with us. The excess payments under these receipts exhibit R2 to R10 come to 39,92,000. Out of that, 17,75,000 is paid by us, and 22,80,000 is paid by him. And that is not a question before the tribunal. Only document is the sale deed. Consideration is 1 crore.
Sale deed is in English?
Yes, sir. I have translated. Your Lordship will get it at exhibit P2A, madam. Translated copy is at page 54. P1 is the ownership deed, P2A is the sale deed at page 37. Translated copy is at page 54. Sale deed is very clear, madam. I just page 54, you also can see the first paragraph. This deed of sale is made and executed of this 15 year 2008 by the below mentioned partners of the so and so. They are the vendors. In favor of your Lordship, you kindly see at page 56. The second one, after the showing the 16 vendors, I have jointly and collectively executed the sale in favor of M. Veerabhadrappa, all of us, appellant and respondent before this court, who are partners of the last sentence in that, who are the partners of Sri Guru Madhu Siddheshwara Swami Associates, the partnership firm. And then your Lordship will get it at 1 crore at page 57, translated for.
Yes.
Second paragraph, henceforth the Kata it starts. In that last 3 lines, we have decided to sell the scheduled property for a total consideration of 1 crore. Now, subsequent to this 2008, no accounts, nothing, balance sheet, nothing is produced because this court shows the complete business are they brought inside. In fact, in respect of 71 lakhs, he says 35 lakhs he paid. So he can't claim that this one. The amount I have paid. 1 crore is the only amount that is paid, and this is the only property available to the court. For it, one can make some time. Arbitrator has dealt with that issue.
Yes.
In fact, the Lord will also see that daily produced by English. All the 13 persons are all the partners who are even settled earlier, all of them are participating. They all speak about receiving sale consideration.
The sale consideration is 1 crore.
So, for this particular sale deed, my lord, because 1 crore was what is shown. What is shown is completely different, probably for the purpose of registration, status, and time. But okay, let us say, even if this 1 crore is the sale deed, there are also payments made to the earlier party. These are all the receipts which are produced. Exhibit, my lord, may kindly see the exhibits produced by me. From right from page 100.
Copies it pertains to me, pertains to the first respondent. On 120 is showing 3 receipts which are in my this one. I have given the amounts. 102, 107, all 8 copies and 100.
Shiva Yogeshwar.
All 3 are in my name. Respondents. Veerabhadrappa is the deceased first respondent. And the second is his wife, W. Jayama, that is at 107. Translated copy. 112. All three are on our base. Arbitration has commented upon that.
Where do you see from 130?
180 also is my document. These are the practical.
All these payments.
Four receipts are in our name for 17 lakhs.
All these payments are being made to the partners.
They don't add up to 70%. All four are in my name.
They need us add up. That is how I have seen in the statement of objections, which is also admitted in exhibit R1. And my lord, there's a clear finding of this honorable court, my lord, which I pointed out, that it is not just 1 crore which is shown. The entire sale dated transaction is for 1 crore and 7 lakhs. Not I just take this. Let us assume for a moment. This honorable court somebody has to buy a property. Any bank finance any can buy a property. They only finance 78%, not for the full amount. That is also, the court can also take notice of the fact. Clearly, because my lord, 1 crore is taken for purchase of the property, we clearly admit in our letter there. We clearly admit in the letter that we have already settled the earlier partners. Why were they settling? They were settling for leasing their rights of the property. If my lord, it is actually for the purchase of the property. Then my lord, for execution of sale date, my lord, 1 crore balance of it, that's paid. This is all my lord. So, my lord,
If that is also paid in equal proportion, where is the problem?
well, it is not paid. That is why I said it is not paid in proportion because the 30 lakhs as per his own admission, not in the legal notice itself. He says, I paid that money. The 30 lakhs, my lord, I had to repay it. Then later in the claim petition, he says, my mistake, few returns, etc., which he read out. That is it. No, that's no cogent proof. He has admitted.
If your contention is that it is 71 lakhs which has been paid, his admission that you paid 30 lakhs will not make a difference because that is less than the half of the amount.
So it does make a difference because it is 1 crore loan was not entirely used for purchasing of this property, but it also includes stamp duty and other amounts, which I don't want to trouble my in my statement of cases are clearly given a breakup how that. But we'll look into this.
Yes.
The Lord has not given any chance of producing documents, which I should have been given a chance because the court refuses to extend the jurisdiction on the grounds that CPC is not approved, which the Lord is wrong. The Lord,
Yes.
It's a different matter whether that we accepted or not. But saying that I will not take it because CPC is not.
Tomorrow. Submitted that state conditional already extends complied with the amount has been deposited. Challenge when receipt is also made available. So, it was the 4 weeks is already over. It will have to be done. What about the respondent? Do something, we'll have to list it and then give it. Otherwise, it cannot be proper. Better to list and give it. Ask them to file the memo. Just a moment, please. Are there any proceedings between the parties with regard to custody in the USA?
There is a JWC petition pending. JWC 124 of 2024
No. The question is this: are there any proceedings pending between the parties with regard to custody of this child in the USA?
No.
When was the marriage?
Marriage was always
When?
90.
When was the child born?
21.
When did the wife come away?
November of last year, 15th month. And immediately filed a JWC case.
What happened to the GNWC?
Partly orders have been passed regarding granting custody to the mother. We have received notice to the recent.
You entered appearance there? Yes.
Briefly, the facts of the case are that both respondent and petitioner were prior to that also gainfully employed in California. They have come down to India, as per the Karnataka to get married. Immediately contact and live together. The child brought to them is a US citizen, not in pregnancy, she never came to India. There was absolutely no dispute in the marriage. In November of 2014, she left when I was not in the States. I had gone out for some work. She has taken the child from school and left a note in the house saying that she wants to go to Bangalore for some medical attention.
No
And
domestic.
come back immediately.
No domestic violence.
There
No.
was no domestic violence.
No
There is a litigation.
protection orders.
No, absolutely no litigation in US. No complaint also made to US. We were completely unaware of she having any grievance in marriage. She never voiced out any grievance. The note that she left by leaving US also is that she wants to visit a doctor in Bangalore and then she will be back.
Which is the note?
Appellation A2.
Make sure A2 is not a note.
Annexure C, Annexure C, page number 28. The light copies are as page number 29. And reader, I have been telling you over 2 months that I am not feeling well, but you did not let me go to India. I cannot continue any longer without treatment. Hence, me and Sri, Peter's the daughter, are going home Bangalore and will come back as soon as possible. I informed all Sati and I have negotiated. The intention was clear that she would come back. It was never to take the child away or to decide media on a permanent basis. This is the note that she reads. And after this, she completely cuts off all communication. I even sent an email, very nice additions, an email asking her, because there was already a doctor's appointment in California, USA, which she has missed because she has come to Bangalore. We continuously writing to her, asking her about the update, and when she intends to come back. She is completely off communication. Suddenly, I start receiving notices from the court for KWC and then divorce. Then she proceeded to file FIR regarding certain abuse, which was never there in her divorce or in KWC case. The court was pleased to stay the FIR. Subsequently, she has even filed maintenance case and domestic violence case. The act of taking a child out of USA amounts to a serious criminal offense in USA. What may kindly see annexure F, section 278 of the California Penal Code. That 278.5, page number 40, my lord. Page number 40. The 278.5 section, every person who takes, entices away, keeps, withholds, or conceals a child and maliciously deprives an lawful custodian of the right to custody, or a person of the right to visitation shall be punished with imprisonment in the county jail not exceeding and skip up para C. A custody order obtained after taking, enticing away, keeping, withholding, or concealing of a child does not constitute a defense to a crime charged under the section.
Why does she need a custody order? She's the mother. She's also a natural guardian.
No, I am being deprived because I'm also a natural guardian.
True.
Most offense because a natural guardian has now been deprived of this.
Hmm.
Now she subsequently getting a custody order even in the US court would not be a valid defense. Now this is as far as the penal code of California is concerned. If the child is taken out of USA, it amounts to a federal offense that is at annexure G, page number 48, my lord. Section 1204, inter-parental kidnapping.
Yes.
Whoever removes a child from the United States or attempts to do so or retains a child who has been in the United States outside the United States with the intent to obstruct the law of parental rights shall be fined under this title or imprisoned for not more than 3 years or both. B1 as because the meaning of child. 2. Parental rights with respect to a child means the right to physical custody of the child. A. Whether joint or sole and includes visiting rights. And B. Whether arising by operation of law, court order, or legally binding agreement of the parties. Now, by operation of law, I am the natural parent, therefore I am entitled to custody, physical custody. Now, without there being any order of the court, unlawfully she has removed a US citizen and brought her out of USA. So this amounts to a very serious offense, it's a federal offense. This is not comfortable. Now, my difficulty is that I cannot initiate a custody court case in USA because USA cannot enforce the custody order when the child is not in the USA. India is not a signatory to the Hague Convention of International Family. Even if a custody order is passed, it cannot be enforced in India. Therefore, the DP is bound to honor a custody order of USA. So there is no point in me filing a petition in USA. In fact, it cannot be filed because USA law says that if it cannot be enforced, the petition So therefore, the custody case cannot be filed in USA once the child is moved out of USA. This amounts to a criminal offence. I am duty bound to inform the police. It will have a devastating effect. The reason why I am not informed the police is that should I initiate a criminal proceeding against her, it will not only devastate the marriage, it will also be devastating to the child. Eventually, what will happen is India is a party to the extradition treaty. So the USA has the power to extradite the first respondent for having committed an offence. As long as the criminal case is pending against her, she will never be allowed to enter USA. She will never get a visa to enter USA. If at all she has to enter USA, it is only if she surrenders herself to the criminal prosecution.
She has contentions of domestic abuse against you.
There is no allegation of domestic abuse. The
That,
allegations.
that specifically is the allegation that she's raised in the.
The allegation which she has made is that I have called her certain waste body and I have insulted her because she has not contributed some money. That is not a physical abuse.
Bad enough, that is domestic abuse.
That may be domestic abuse as far as the criminal offence is concerned in USA, does not amount to a defense. If she were to claim that domestic violence has been committed against her and she was unable to even bear with the US, that is a defense which is permissible for her, but the defense can be taken only after she surrenders herself to US and submits herself, only then she can prove such a defense. But until then, she is a fugitive at law. If should I initiate criminal proceedings? Now, if I initiate criminal proceedings, eventually what will happen is the child is a citizen of.
Are you here in India?
Now, but my mother. My parents live here, and I intend to save the money. That is essentially why I'm not initially escalating this matter, because I intend to save the money. Even to this day, I have no idea what reason she has. She never raised any dispute when we were living together. That is apart. Now, the problem is that should I initiate, I'm dutiful to inform the police sooner or later. They have a provision of initiating an administrative complaint where I inform the authority because they don't register a official criminal record. That is what I have done. And that gives me certain number of months for me to pursue legal remedies on the civil side. That is what I'm doing. Now, if it escalates into a full-fledged criminal case, what will happen is that the daughter being a US citizen, one way or another has to be repatriated back to the US. The US citizen cannot be kept outside US indefinitely. Now, if she is repatriated back to the US and there's a criminal case against the mother, she will never be given visa to go and see the child unless she surrenders herself to criminal investigation. If she were to be prosecuted, even if she is acquitted, the law is that once a child abduction case is registered, she will never be left alone with the child. There always has to be an escort along with her. That will completely ruin the mother and child relationship. I don't want to put my child through such thing. I don't want to ruin my marriage. I don't want it to escalate into a full-fledged criminal trial in the US.
You're sure that the marriage is at a situation where it can be saved?
Yes, even though we never had any discussion, it does not become easily reconcilable. We have not to met each other after she came to marriage. She's cut off communication. I intend to resolve and.
How do you intend to participate in the proceedings? How do you intend to participate in the proceedings if that is your intention? The petitioner.
In the MC case, I have not yet filed my written statement. I will receive notice. In the MC case, I only intend to refute the allegations and ask for dismissal of the divorce.
That is not what we mean is, if the child is brought, this cannot be a proxy war. You will have to participate in the proceedings with regard to your intention in the matter, how you intend to go about this. Can you participate online in the proceedings?
Yes. In fact, today the petitioner was ready to come online. He asked me if it is required. I said that it would not be required.
Do that in. Yes, please.
I got to the.
Yes.
Now, I have not escalated the matter to full-fledged criminal trial because that would completely devastate the entire family, including the child. The child has been educated completely in US. He has never come to India at any point in time.
We understand all that.
The academic year starts in July.
We understand all that. The question is it a reconcilable difference? If it is, probably there is something which can be done. If not, then the law has to take its course.
The respondent number 1 is destitute. They have absolutely no money. No money. That is what they have.
Never mind that. The best interest of the child will be considered in the custody proceedings. The issue is this: is a habeas corpus writ petition maintainable? Would be the issue. Let's hear the other side of that.
Regarding maintenance, you have also. If the custody petition before GWC had jurisdiction, then I would have proceeded before. Your lordship can dismiss the habeas corpus and relegate me to appear before GWC. Had the GWC court had the jurisdiction.
That is the point I want to hear the respondent on. Yes, what do you say?
With regard to the government stating that there is no differences between us, these are matters to be decided before the trial. I have certain issues with the marriage. I have been subjected to a certain degree of domestic violence, and that is for the trial courts to decide. Why I have not initiated.
The contention appears to be that whatever that be, the child being a citizen of the USA, what you have now done is illegal, and the courts here will not have jurisdiction is the issue. Yes.
First, I would like to address the point of the criminal notice. Here, Section 278 of this California Penal Code reads every person not having the right to custody, who maliciously takes, entices away, keeps, withholds, or conceals any child with intent to retain, conceal.
That qualification is not there for 278(5). Any person. It does not have to be malicious. It does not have to be a person who does not have right to custody, etc. 278(5) is different. So what the offense is that you keep a child away from the custody of somebody who also has a right to custody. Both parents have a right.
This is where I would like to bring up Lordship's attention to 277, Section 277 of this particular. Well, here the right of custody is explained. Here, now absolutely there is no law that can state that a minor child being with the biological mother is going to be unlawful custody or illegal.
It is not.
It is not.
It is not. That is not the issue. But keeping a child away from the lawful custody of another parent is also an offense.
Yes, madam. Yes, madam, I'll come to that. Madam, with regard to this, the applicability of this entire Section 278 and 277 will come into effect when there is a custody order in favor of the parent that is not having custody. Madam, here no, admittedly, madam, there is no custody proceedings initiated in the US. Naturally, madam, there is no order that is stating that he is supposed to have interim custody of the minor child and I am not supposed to have interim custody of the minor child. In that sense, the applicability of 278 and 277 will not come into picture because there is no effective order passed by any competent court in the court of US stating that the father is supposed to be the interim custodian of the minor child. And there is no order and there is no operation of law that states that I am not entitled to have interim custody of the minor child.
Just a moment, Counsel. We understand all this.
Right.
We understand your legal arguments. Please tell us, do you have an argument that a child is not best off with both its parents?
With regard to that, it's like now with the issue comes into international parental kidnapping. One point I need to wish to point out within the provision itself is 1204. It is in clause C. It shall be an affirmative defense under this section. There, subclause 2. The defendant was fleeing an incident or a pattern of domestic violence. I am trying to flee from an incident or pattern of domestic violence. Then this particular provision that is under 1204 of the International Parental Kidnapping will not be applicable. So as such, here the applicability of parental kidnapping and federal offences does not come into picture.
Yes.
GNWC proceedings have been initiated here, true enough. And till date, I have not denied any visitation. Let them file a visitation application before the trial. What I will more than happy to comply with the visitation. Visitation can be expressed online as well. They can apply for an application seeking visitation of the minor child, and I will comply with that.
Why is it necessary, if you really are sincere about that, why is it necessary that they file an application for visitation? You don't have a case that the writ petitioner here is not the father. Why can he not speak to his child? Do you need an order of visitation for a father to speak to his child?
No, I have not denied visitation at any point of time.
How many times has the child spoken to the father?
No, that time I don't have specific search.
Please let the mother come. Please keep her present. Let us speak to her and let's see whether this can be resolved in some manner without escalating. We are not interested in either of your rights. You may have several rights as parents. It is a child who is our concern. And there can be no better option for a child to grow up in than with two parents, with both its parents and as a family. Correct? If there's any way that the marriage can be salvaged so that the child has a normal upbringing, that should be the first effort. Correct? So
And otherwise, my lord, even the divorce proceedings that has been initiated, if they enter an appearance, then the matter has to be referred to mediation at some point in time. As a mandatory procedural requirement itself, the mediation session has to be read. And if there is any way of salvaging the marriage, certainly we are going to exercise.
whatever this be, wherever the child is, you cannot keep the child away from the custody of the other parent.
Madam, we are not keeping the child away from the custody of the other parent. Our intention is not to cut off the child from the father. This is not how.
Then how else when you travel halfway across the globe and bring the child to a place where the other parent has no means to contact the child? You don't even say that the father has spoken to the child once in all this time that she's been here.
Madam, these are certain things that have to be determined by the client.
Yes, please keep the respondent present. And please require that child being brought, please let the court decide. Yes, please, that will.
Should she come back to the US, we make an arrangement for separate in case she fears living with the petitioner. We make an alternate apartment for her near the house so that the child will have both parents.
Let us see.
Even if they cannot live together.
Let us see. That may not be so easy. Let us see. Let the mother be present with the child.
We have not seen the child.
Seeing the child can be arranged. Don't worry about that. When? Monday at 2:30. Please come. In the meanwhile, instead of precipitating this, can't you allow the father to speak to the child over phone, over WhatsApp calls? Please don't. Let us see. If by 16th the communication is not restored, we'll see what can be done. Not in the court. We don't want the child, a 4-year-old child. As much as can be avoided, let's avoid having the child here. So in the meanwhile, please see that the child is permitted to speak to the father at least over WhatsApp calls. And don't let the father and mother speak to each other over WhatsApp calls at this stage. Let them first come here, let's talk to them, and then after that, let's see how things go. Yes. The heard the learned counsel for the petitioner as well as learned counsel for the respondent. The learned counsel for the respondent is required to keep the respondent present before this court on 16th at 2:30 in chambers.
2:30 in chambers.
In the meanwhile, the respondent shall permit the petitioner to interact with the child over WhatsApp calls. Please, you can arrange the when and where of it.
Supreme Court, my lord, after the last round, my lord, when the lordship felt that everything had not been looked into, there's one, my lord, development. We have filed a certain, an application for additional grounds because of a certain amendment in the law in the latest decision of the Supreme Court. That is pending consideration. My lordship may kindly consider and allow that application for additional grounds. And that is, my lord,
What are the
IA
additional
number
grounds?
1 of 25.
IA 1 of 25 is not available online. This is in which MFA?
It is, my lord, there are two matters.
Yes.
MFA 5575,
This is in the second one.
5578 of
7/8 of
17.
Just a moment.
In that, my lord, we are the appellants, we are the landowners.
IA 1 of 25.
Yes, my lord.
Okay. Additional grounds, additional prayer. What about the IAs? Have you filed any objections to the IAs? They are for grounds. Filed.
No, my lord, not filed. They have formal additional grounds, my lord, they may be able to oppose it on legal grounds. There's an inordinate delay, my lord, in finalizing the acquisition. So we have relied on certain pronouncements which say that you must shift the date in such a case.
Oh.
That is one ground. The second ground, my lord, is what is the quantum
Even
of
without
solation?
such a prayer,
Yes,
under 142, the apex court definitely can do it.
please, ma'am.
The apex court is also held that this court under 226 can also do it.
Please, ma'am, please.
Therefore, even without the prayer, it may be possible.
True,
Without the
Lord.
prayer and the grounds also, it may be possible for this court to do that.
Please. But since it had not been formally raised, other side may feel that you're arguing a point which you are not raised it.
You've raised the issue of inordinate delay.
Yes.
Will that not do?
That is true, my lord, but so far as shifting the date is concerned, out of abundant caution, my lord, I thought I should file it.
Yes. What is the acquisition for?
The acquisition, my lord, it was initially requisitioned under the Defence of India Act. And after several years, my lord, a portion of it was acquired for the purpose of Air Force station. We are not challenging the acquisition. The only challenge is relating to compensation.
What do you say?
There was an amendment, my lord, which provided that the new Land Acquisition Act will apply to acquisitions under that law also. So that also I've added.
Yes. When was the IA filed? 5 months.
January 25.
5 months ago.
No, IA could be allowed, my lord, subject to their objections.
IA can be allowed. And with regard to the prayers being allowed, we'll consider your objections at that stage.
Please.
Heard the learned senior counsel appearing for the appellant in MFA number 5578 of 2017. It is submitted that 2 IAs have been filed seeking to raise additional grounds in the appeal. Though the learned counsel for the respondent submits that objections are to be filed in the IA, since it amounts only to adding additional grounds. IA 1 of 25 is allowed, subject to the objections
Please.
of the other side.
Some date your lordships may consider fixing, because there's a direction of the Honorable Supreme Court that it should be decided expeditiously.
During the course of the week, you're ready? It can be retained in the list.
Monday or Tuesday? This week?
Yes.
Please. Please.
Sorry?
The paper books are not filed, and the entire order of the trial court runs to about 30 pages, which is in Kannada. Your Lordship may give me a week's time, I will file the entire thing as the translated copies, Your Lordship. A week's time may be given. Plaint is rejected is a simple matter question of, only thing I have to produce the translated copy because it is elaborately discussed by the trial court.
30-page judgment to
Yeah.
reject a plaint.
Yes.
Yes. The learned counsel for the appellant seeks a short accommodation on the ground that the judgment under appeal is in the vernacular. List after 2 weeks.
Very well, madam. 1 week will do, Your Lordship, if it is not inconvenient to your court.
Give a date if date is available.
Very well.
Yes.
Appearing on behalf of the respondents, my lord.
Well, again, you're not appearing.
Appearing on behalf of the respondents, my lord.
Why is she not appearing here? Who appears for the appellant? Any appearance for the appellant?
My lords, a week's time may be granted to seek instructions from the client, my lords. We have come on record on Wakalat on 2nd April, my lords.
Why is somebody visible on that and not on this? Yes. Let's start. Give a date.
Much obliged.
Representative, 6 and 7, they responded. This, there was
Partition.
partition. Other advocate was here, I think. You kindly grant some time.
Just
Because
a
it was
minute.
posted for settlement.
There are 2 appeals.
Yes, ma'am.
Partition suit decreed.
Yes, partition rejected. Yes.
It's not rejection of plaint.
No, no, no.
Rejected on merits.
I am the bona fide purchaser.
Just a moment. Can we take this up?
For a while, it's coming actually. My senior counsel is coming on the way.
Why is partition declined?
Because it was before 2005, it was
That is all there is to it.
sale deed has been
There is a
executed.
registered partition deed before 2005.
Not a registered partition. Yeah. They have sold, registered sale deed is there.
Before 2005.
Before 2005.
2012, 2005.
Yes.
Daughter's suit for partition.
Yes, my lord. 2011 they were filed.
So she admits that she's sold portion of suit schedule properties under 3 registered sale deeds 9/7/2002, 26/6/2003 and 1/12/2004 in favor of so and so. Visitable suit schedule properties. can still claim partition in respect of surviving properties. Till 2005,
Yes,
whatever has been sold is sold.
yes,
But she can still claim share in
yes.
respect of remaining properties, can she not?
Yeah, she is entitled because
But what is she sought?
she want this property also. I think a week's time permitted so that we can argue.
If the family has more properties and if only these properties are sold, she can probably claim partition in respect of other properties. But not in respect of properties which have been sold in 2005, she cannot claim.
So,
They have other contention also, my lord. So better let them be.
Just a moment. Family partition is also pleaded. Family partition is pleaded.
No, but there is no partition like the registered partition or anything.
You are unconcerned with that. You are concerned only with your property, the property that you
Yes,
purchased. You are the purchaser for
I am the purchaser.
2005 itself.
Yes.
Or subsequent.
No, before that only.
Yes. Learned counsel for the appellant seeks time. Synopsis, notes, etc., etc. If you need anything, please let us know.
Please.
The trial court records are here.
a week's time may be granted, my lord.
List after 2 weeks.
This matter is food for specific performance, defendant's appeal. And these depositions and certain exhibits are in Canada. 2 weeks time may be granted. You are translated from.
There's no chance any
Any
bill
matter
is
is
going to be taken up
taken up.
because of this contention. This is the difficulty of having.
Unless roster is
Yes.
little changed. Otherwise, at least one has to be there to understand the Kannada so that my lord could assist.
We don't actually need translations of everything. We can, if one of us knows Kannada, it can be handled.
Yes.
But then when both of us are
Yes.
don't know, then it is a problem.
We can apprise the facts and law, there is no doubt about it.
But when it's a
But
first
ultimately,
appeal-
if your lordship looks into the evidence, my lord, if your lordship wants to interpret, my lord, then it may require.
When it is a first
And
appeal,
the whole difficulty, my lord,
civil appeal, it may not be proper to.
we don't have an expert here, my lord, a translator. Once again, we have to redo the thing, my lord, once it is translated, your lord.
And AI translations are very risky.
Yeah.
AI translations cannot be relied on.
Yes,
not,
relied
not
upon.
as yet.
Even Google also, my lord, that is also not correct, your lord.
It's not correct. You
Not
can't
correct.
rely on it fully.
We cannot,
We'll
unless
have to
we
read it again and
Yes, yes.
redo the translations.
Yes. Unless we ourselves make an attempt to get it the English translated, my lord, it is very difficult.
Why is there a writ petition along with this?
There's arising from execution of this verdict.
Yes.
Very incidental.
Yes.
Let him file, my lord, within specified time, my lord, otherwise
2 weeks.
I got the sale deed through the court, your lordship. He is enjoying the benefit, your lordship. I borrowed the money. I paid the money. Court executed the sale, my lord, in my favor. He is enjoying the benefit, my lord, taking rent, everything, your lordship, since 2015.
Commercial
my lord.
building.
Yes, my lord.
Commercial.
Building, my lord.
Yes.
Residential building.
Please do it within 2
No,
weeks.
it is rented.
It is rented, but it is residential. It's a Moda site.
House.
Muda site. Mysore.
Muda site.
Oh.
Yes.
File
At the request of learned counsel for the appellant. List
Need-
after 2 weeks.
Any date is given.
Yes.
Tense. If it is
Translations.
possible early, my lord,
Translations shall be made available by that.
grateful.
I appear for the respondent. This is an appeal, section 37 of the Arbitration and Conciliation. But I say so as the first sentence to point out to my lords that I am aware of the limitations of section 37 and what my lords been in relation to an appeal under section 37. But a claim was filed before the learned sole arbitrator
Yes.
by the claimant against me, arising out of a memorandum of understanding between the parties, which was marked as Exhibit P1 before the learned sole arbitrator. But there are a few documents in Kannada, but I don't think we are not going to place much reliance on them. Those documents' existence is not in dispute. For example, there's a Pollution Control Board approval. It is in Kannada. But approval is there or not, neither he is disputing nor am I disputing. But there are a few documents, but none of them are touching upon. Your lordship may not have to go there. But the document based on which the dispute, alleged dispute arose between the parties is the memorandum of agreement marked as Exhibit P1. But before the learned sole arbitrator, my learned friend appearing for the claimant would seek, my lord, several reliefs. One of them, the first of the reliefs that my learned friend would seek was a relief of specific performance. A specific performance to execute and register a joint development agreement, to act on the memorandum of agreement. And again, this was more or less a real estate transaction gone sour between the parties. As per the appellants, the respondents could not fulfill the requirements of the memorandum of agreement. As per the respondents' claimant before the tribunal, but we have not done our part of the transaction. There are three different parties, my lord. Of course, there are to the agreement there are parties in number are 5, but they have to be lumped into 3 different categories. Your lordship would have Exhibit P1, lords, from the documents.
P1 from the documents. It was agricultural land.
Agricultural land. But this memorandum of agreement was for the purpose of conversion, providing the services, liaison services for converting the agricultural lands to non-agricultural residential purpose. Your lordship have the agreement. But if for just till the documents would come, Lord, may I just seek lords kindly come to in the memorandum of appeal itself. The arbitration award, Lord, is at page 47.
Yes.
The lumping of the parties, I'll just try to demonstrate to my lords. Lord, the claimants are the second parties in the agreement. The lordships will see there are 2 numbers of claimants. Then, Lord, the respondents before the tribunal, there are 5 in number. Lord, one is one lump who are owned 17 guntas of land. He put it in the contribution. 2 and 3, another lump who owned about 5 guntas, 5.01 guntas.
Yes.
4 and 5 is another lump. So, my lord, I would request my lords to consider it as 3 parties only. Though there are 5 in number, 3 parties. One owning 17 guntas, 5 guntas, and 6 guntas. Not all these parties put their lands together, and the claimant would promise them that he will get the lands converted. That is the memorandum of agreement, Exhibit P1. In addition to the claim,
yes,
Exhibit P1 is the document. Before I would take my lords through the documents, the relevant clauses. The claim before the tribunal was first prayer was for specific performance. It was rejected. That request was rejected by the tribunal. Then second prayer was in relation to damages. Third prayer was in relation to reimbursement of expenses. Those are the issues framed by the learned tribunal. But specific performance, tribunal would say negative. Then 2 and 3 regarding damages and expenses. Exorbitant damages and exorbitant expenditures for claim. The tribunal would say part of it is fine, and tribunal would allow part claim only. Then, fourth issue, the burden is on the
the appellant to point out whether or not the amount which was sought to be not a set off, is that the only amount for the purpose of conversion or something else is the amount. No, that is the clause that I'm going to read now. So that my burden, the burden which was put on me by the tribunal is not the finding is in the negative. So not I not in relation to the relief of specific performance, the claimant would be unsuccessful. In relation to damages and expenditure, the claimant would be partly successful. And in relation to my claim that he was not supposed to, the second party was not supposed to spend more than 2 lakhs of rupees, I was not successful. So I'm not coming to the exhibit P1. Your Lordship may kindly see the first name H.M. Tyagaraja is the appellant before my lords in this appeal. 2 and 3 is the second lump. 4 and 5 is the third lump. So I'll skip the parties part there. And your Lordship will kindly see that these are the owners, landowners are the first parties, and the person who promised that he will get the conversion, the 2 numbers of persons, they are the second parties as described in the title of the document. Now the relevant clauses are clause 1 and 5. The recitals, your Lordship could see that there are 3 different portions lumped together, and the scheduled property would be about 30 guntas of land in the first page itself. In the next page, again in the recitals, your Lordship would see, whereas the property bearing survey number so and so, including portions which have been sold by Shri H.M. Tyagaraja, are contiguous and continues to be an agricultural land, though they are suited for developmental purposes of non-agricultural in nature, namely for building commercial / residential complexes. Since the lands are not converted into agricultural lands, they cannot be put to the said use before they are converted. The parties of the first part who are owners of the land are not possessed of any expertise and financial support to get it converted, and whereas the party of the second part is into construction business and have necessary infrastructure and expertise in the matter of construction and have necessary expertise for getting the land converted into non-agricultural, and party of the first part is desirous of getting the entire land converted into non-agricultural land and also enter into a joint development agreement in respect of portion of the land, and therefore have approached the party of the second part, and the parties are desirous of entering into this memorandum of agreement on the following terms, indicating particularly the terms agreed so and so. Clause 1. The party of the first part has entrusted the job of getting the land converted, land in survey number so and so, situated at so and so, measuring to an extent of 17,000 square feet, converted into non-agricultural purposes, namely residential purpose, which the party of second part shall get it done through their own personnel. The party of the second part, to get the said conversion obtained, shall spend up to a sum of rupees 2 lakhs, which amount shall be refunded by the party of the first part without interest at the time of final settlement of the amount as agreed to in this agreement. It is distinctly agreed that if any additional amount is required to be spent for getting the land converted, any amount in excess of rupees 2 lakhs shall be borne by the party of the second part, which the party of the first part shall not be entitled to claim refund. It shall be to their debit. But this last 2 portions, last 2 lines, to me it is slightly difficult to understand. Why I would say that, I'll just canvass my point there. This is not an ambiguity insofar as my respectful submission is concerned. The last 2 lines.
The party of the first part is the landowner.
Is the landowner. Party of the second part is the developer, though not a developer yet, it is only an agreement for conversion. Let us call him developer for convenience.
The person who has agreed to do the conversion.
Yes.
Whatever that is.
So, my lord, I'll read that second unnumbered paragraph once again, if my lord permits me. It is distinctly agreed that if any additional amount is required to be spent for getting the land converted, any amount in excess of rupees 2 lakhs shall be borne by the party of the second part. I'll pause here for a moment. There, my lord, it says Here, more than 2 lakhs, my lord, the party of the second part shall bear. If it stopped there, my lord, absolutely no ambiguity at all. But it goes further. It says, which the party of the first part shall not be entitled to claim refund. It would not make sense. But if it probably would have made sense if the party of the, in place of party of the first part, it would have been party of the second part. So they cannot claim refund more than 2 lakhs. But it is not to be so. Then next sentence, it shall be to their debit. Whose debit? It's not clear. But this is my respectful submission. But I would say this ambiguity in this clause, the plain literature ambiguity, I'm not saying anything else. The plain literature ambiguity should have been clarified by way of leading a proper evidence, acceptable evidence, at least. What I'm saying is, at least verbal evidence of the witnesses should have been led to clarify what this last 2 lines means. It is not done so. But the learned arbitrator would understand it in a manner whereby he would say that more than 2 lakhs also, it is the party of the first part was to bear it. So, my lord, from this context, since I have submitted to my lords what the finding of the arbitrator is, kindly permit me to read entire clause 1 once again. Because it's entire clause 1 and clause 5 is where the interpretation stands. The party of the first part has entrusted the job of getting the land in survey number 182 so and so 17,000 square feet converted into non-agricultural purposes, namely residential purposes, which the party of the second part shall get it done through their own personnel. Full stop. The party of the second part to get the said conversion obtained shall spend up to a sum of rupees 2 lakhs, which amount shall be refunded. It should have been reimbursement, which amount shall be refunded by the party of the first part without interest at the time of final settlement of the amount as agreed to in this agreement. It is distinctly agreed that if any additional amount is required to be spent for getting the land converted, any amount in excess of rupees 2 lakhs shall be borne by the party of the second part, which the party of the first part shall not be entitled to claim refund. It shall be to their debit.
If it is, shall not be liable to reimburse, that covers it. But is it what is meant? Is there evidence laid on that?
No evidence. Absolutely no evidence.
It shall be to their debit.
But I would also not read it multiple times. I read it to myself several times. But still, the ambiguity remains. By no stretch of imagination, without supplying a few words, taking away or modifying a few words, it's not possible to understand this.
What does the arbitrator say?
Arbitrator says it is to the para 28 of the award and also para 20 also. But I'll just, before my lord, go to the award. Kindly come to clause 5.
Yes.
It is in aid and supplementary to clause 1.
Yes.
But of course, apart from this 2 lakhs, there is other amounts payable also. That also I'll read it later. Since we are understanding clause 1, clause 5. It is further agreed that as agreed to above, the amount of rupees 2 lakhs spent by the party of the second part shall be refunded to the party of the first part at the time of the final settlement, and any additional amount is required to be spent for conversion shall not be refundable by the party of the second part to the party of the first part. It goes totally contrary, clause 5. And still it makes the picture more, I would say, blurrer, for want of better word, more obfuscated. This is clause 1 and this is clause 5. Of course, there are other clauses. I'll read, I'll take my last through the clauses.
Shall we go to clause 2 now? 2 and 3?
Very well, I'll read. As soon as the party of the second, clause 2. As soon as the party of the second part gets the land converted into a non-agricultural purpose, the party of the first part shall hand over possession to an extent of an extent of 17,000 square feet of the land in survey number so and so, situated so and so, measuring 29 guntas, which land shall be developed by the party of the second part by putting up construction of residential apartment complex, and in the residential complex, once construction is complete, the party of the second part shall retain 60% of the built up area, and the party of the first part shall be given 40% of the built up area jointly. The party of the second part has agreed to give a sum of rupees 15 lakhs as interest fee security deposit, out of which a sum of rupees 3 lakhs is paid at the time of entering into this memorandum of agreement through checks number so and so, and the balance of rupees 12 lakhs out of the said advance security deposit shall be paid by the party of the second part as soon as the conversion of the land is taken place, and the party of the second part is placed in possession of 17,000 square feet for the purpose of joint development. The party of the first part shall return the said interest-free advance security deposit of rupees 15 lakhs to the party of the second part on completion of the construction on the said 17,000 square feet of land, and after the first party receives its 40% share of the built up area, the said advance security deposit of rupees 15 lakhs shall not carry any interest. In clause 5, I have already read, but I'll read it again. It is further agreed that as agreed above, the amount of rupees 2 lakhs spent by the party of the second part shall be refunded to the party of the first part at the time of final settlement, and any additional amount is required to be spent for conversion shall not be refundable by the party of the second part to the party of the first part. Clause 6, it is agreed between the parties for convenience that along with this memorandum of agreement, a plan is prepared which shall show the portion of land which the party of the first party shall be giving to the party of the second part, measuring 17,000 square feet for development purposes, and the plan annexed to this memorandum of agreement shall be treated as part and parcel of the memorandum of agreement. It is agreed between the parties that as soon as the conversion of the land is over, a regular joint development agreement specifying the details of the construction, mode of construction, time within which construction shall be completed, etc., shall be specified, and a regular joint developmental, it stops there. The parties have agreed that they shall cooperate with each other in achieving the object for which this memorandum of agreement is entered into, and the party of the first part, wherever and whenever required, shall sign all necessary papers for obtaining the conversion and shall cooperate with the party of the second part by executing the GPA. 9. The parties have agreed that any dispute between them shall be resolved through a sole arbitrator, and the provisions of Arbitration and Conciliation Act shall apply. Clause 10. It is distinctly and clearly agreed between the parties that the party of the second part shall be liable to pay the further advance of rupees 12 lakhs only after conversion of the land detailed out in the schedule is obtained, and the party of the first part places the party of the second part in possession of 17,000 square feet of land which is agreed to be jointly developed. The party of the first part has represented that in view of they are being absolute owners and in possession of the lands, and there are no claim by any other persons, the party of the second part has agreed to enter into this joint developmental agreement. This is the agreement based on which the dispute arose subsequently. What this agreement, if I can summarize, there is one set of parties who are the owners of 29 guntas of land. There is another set of parties who claim to be developers, who said we'll develop. We'll convert the lands and thereafter develop. Convert the lands for only non-agricultural residential purpose. Though in the recitals it very clearly says residential is also possible, commercial is also possible. Parties were aware that both were possible, but specifically the owners wanted residential, non-agricultural residential conversion only. That is what was promised also by the developers under this agreement, that they will get it converted for residential, non-agricultural residential purpose.
there is a cap of rupees 2 lakhs, which is to be reimbursed, as I understand, my lord, which is to be reimbursed by the owners to the developers for the purpose of carrying out. Not, we could say it is their share of the expenditure, the owner's share of the expenditure towards the conversion, for a sum of capping it at a sum of rupees 2 lakhs. Beyond 2 lakhs, I would respectfully submit, beyond 2 lakhs, there is no question of reimbursement. It is their own account. That is my respectful understanding.
There may not be any necessity for a reimbursement at all, because it would only be an adjustment. 12 lakhs
yes, but eventually
are due as advance money as soon as the conversion is done. Probably it'll only
eventually,
be an
yes.
adjustment.
Most joint development agreements, 99% of them that I have seen, not in my limited experience, generally they are adjustments only. The amount is adjusted towards some built up portion of the built up area. But in this case,
So in this case, even that is not required, because 12 lakhs is due immediately after
Yes.
conversion.
It
The
was not
builder-
due, ma'am.
The builder has to pay 12 lakhs.
12 lakhs.
Once the, as advance,
As advance.
refundable advance.
Yes, ma'am. But in,
That
yes,
probably it could have been adjusted.
yes.
Those
But
2
in this
lakhs
case,
also
yes,
would
but
have-
in this case, not the 2 lakhs which was supposed to be spent. But apart from that, this 15 lakhs, security deposit, advance security, interest-free security deposit which was to be paid, that was paid under this agreement. There is no dispute on that. Your Lordship, you kindly see, there are 3 lumps of owners, party 1, party 2, party 3, 17 guntas, 5 guntas, 6 guntas, each of them. All 3 lumps get equal share in the advance security deposit also. It's not depending or proportionate, what my learned friend was saying the other
It's
day.
not pro rata.
Not pro rata, advance is not paid pro rata. But at this stage, I would pause for a moment and place this again at my through my learned friend also. The 2 other lumps of owners, my learned friend has settled with them. There is a finding of about 60 lakhs odd by the learned arbitrator. 2 of them, my learned friend has settled for a sum of rupees 18 lakhs each, 5 guntas and 6 guntas. But in my case, I have there is no settlement. I am the only person who has challenged this. The other 2, they have already paid and settled. So my amount is in deposit before this on by virtue of interim order granted by this on. But advance security deposit, there was no distinction. Even today, my offer stands, if my learned friend gives me the same bargain, I could this could be disposed of.
Yes, my lord. Now, coming to the aspect of settlement, way back 3 years back, 2-3 years back, it was very well requested among all the 3 people to settle it for 21 lakhs. At that point of time, due to existence of the stay order, the appellant refused to settle at that point of time. This offer was very much given at that point of time. To be precise, total extent of land 29 guntas were converted for the residential purpose, and the fruits yielded were very much eaten by the appellant. Today it is worth more than 10 to 15 crores, my lord. My money of 15 lakhs is stuck from 20 years, my lord. In the real estate industry, after 20 years, the money 15 lakhs would have been, it could be imagined.
Not all that I'm saying.
And apart from that,
if my learned friend is not agreeable,
no,
continue
it is
further.
not like that. I'm not denying that fact. See, you are very much welcomed at that point of time. But right now, at this stage,
Now, what is your, what do you say?
my clients are not agreeing for what the previous settlement amount, my lord, because a portion of the converted land is 17 guntas when it comes to the upland, whereas the others are 5 guntas only, my lord. And
Is it true that this 15 lakhs was equally shared between the 3 owners?
it is, my lord.
45?
It is, my lord. Lord, and as far as coming to the
If there is any scope of any settlement between you, we don't want to stand in the way. But if there is no scope of settlement, we'll go ahead and hear the matter.
My amount is already here, not in deposit before my lords. All that I'm saying is, give me the same bargain. If it is there, I have instructions right now.
Lord, roughly speaking, considering 9% interest only from way back 2014 to till date, it crosses 1 CR, my lord, to the portion of the
Just a
appellant.
moment. Is this amount not in deposit?
Lord,
Is the amount not in deposit? Is it not in fixed deposit?
It is
in the
50,
deposit.
50% of the claim amount has been deposited, my lord. in the court, for which I had filed an application for the refund of the same, my lord. My lord, as far as the calculations goes, it goes beyond 1 CR as of today from 2014 to till date if it is takes, my lord, to the extent of land what has been converted to the appellant, my lord. In that context, if they are ready to bargain between 30 lakhs and 1 CR, I can propose my client for the settlement, my lord. Because the older version of 21 lakhs is ruled out, my lord.
22 lakh. But I am told not the other two owners have given 18 lakhs to him in 2022 itself, not long ago.
No, my lord, it is not 18 lakhs, it is 21 lakhs, my lord.
18 lakhs.
In
It
2020.
is 21 lakhs, my lord.
Huh?
21, my lord.
If you're willing to talk about the amount, if that is all there is to it, then we don't want to go into the
But
merits of
if
the.
the other two have got 21 lakhs, I will instruct my client to not agree for 21 lakhs.
Or
That was in
anything-
2022.
Yes, or
Yes,
anything further, probably the.
No, my lord, if it is
interest
21 lakhs, my clients are not agreeing, my lord.
Then I'll proceed further.
Yes,
But as far as the spending of 2 lakhs over and above, I am not permitted to spend, my lord. That's what my learned friend has said. You know, kindly come to.
no,
I'm not completed. Okay, we are only.
yes,
Yes, ma'am.
you're sure there is no chance of settlement?
No, my lord. If it
Yes.
is 21 lakhs, I'm sorry, my lord.
Well,
Yes,
but I am also aware while I proceed further, my that security deposit of 5 lakhs is with me. I am also aware that that amount will have to go to him. So, I am not arguing for a total closure. I am only saying that 5 lakhs which I have received as refundable security deposit, that has to go back. So, my only endeavor will be to demonstrate to my lords that the award, not the damages, the direct damages, indirect damages, expenditure reimbursement, all that is not to my account. That is all that I am trying. Now, I'm not coming to with this.
just a moment. Therefore, apart from the 21 lakhs, you're also ready to give the 5 lakhs.
No, not apart from that. I have received 5 lakhs, not as a. So that amount I have to refund. That amount I have to repay. There is no doubt about that. I am not saying I am entitled. There is some kind of forfeiture and all that. I am not arguing. There is no forfeiture here. That
Why we are only asking you whether you can arrive at some via media with regard to the money.
not a,
That is all there is to it. We need not go into this entire thing
Yes,
at length and then have you settle.
My lord, if it is 21 lakhs, I'm.
Please speak to each other.
Lord, that is, it has been proposed.
21 lakhs, now he says 5 lakhs in excess.
no,
That
not
takes-
excess, ma'am. I'm
That
only
is
saying
part of 21 lakhs. Part-
because the entire amount, ma'am, the arbitrator says entire amount is about 60 lakhs. The arbitrator has awarded. Out of 60 lakhs, not 3 lumps. Not he has already got 18 lakhs each from the other 2 lumps.
He says 21 each.
I'm sorry, 21 lakhs. So it becomes 42 lakhs. Not remaining is 18 lakhs. Is that? But,
Anyway, admittedly,
yes.
your share in the properties is more. So if you can,
No, but yes.
attempt a settlement at something further,
not all that I would say is
We will not
that
stand
even
alone.
though my share is more, but the advance that I got was same as what the other 2 got. But it was never a distinction based on the quantum of the property. That
they've clearly said 21, they are not willing. Let's go ahead with the.
we'll go. I'll go ahead.
Yes.
So even going ahead, I'm saying I'm not arguing for a complete allowing of the appeal. I am aware of the fact that I have to refund the amount of 5 lakhs advance security deposit. That much I would respectfully submit.
Yes.
So coming to the issues frame, based on this, after this, pursuant to this memorandum of agreement, I have received, as per the terms of the agreement, I have received the advance security deposit of rupees 5 lakhs, not in dispute.
Yes.
But we could not proceed further in relation to execution and registration of a joint development agreement. It was not just me, the other 2 parties also included. We wanted, we wanted not a residentially converted piece of property, which did not come. The conversion was for non-agricultural commercial purpose. Of course, my learned friend would argue that it is more in value than the residential and all that. But we specifically wanted residential for the purpose of retaining a few units of apartments for ourselves. So that was the one of the reasons, of course, sentimental also, but that was the agreement also that it should have been converted for the purpose of. Then the claim would also indicate that there are no litigations in relation to the property. It was pointed out to the developers that their litigations were there in relation to the property. So the developer would not proceed further to the next stage because of the pendency of litigation in relation to the scheduled properties. So it is not just a one-sided refusal to perform. It was both sides, not even the developer was not agreeable to proceed further in view of the pendency of several litigations. That is also the finding is there in the arbitral award itself. So
the agreement records that there are no other claims.
No claims whatsoever. So based on this, since the relationship did not go to the next stage, next level of going to the joint development agreement, and thereafter, of course, the development, of course, conversion took place. Some monies were spent by the developers, and that was some documents have also been.
What was spent?
That is there, not recorded in the award itself. I'll take about 60 lakhs. The details are there. Not at
60 lakhs for conversion.
No, for conversion.
Incidental expenses.
Sorry.
Conversion, I'm only on the 2 lakhs.
For conversion, yes, ma'am.
How much did it go up to?
For conversion, they claim that they have spent about 1,26,514 for conversion.
So therefore, the question of whether those more than 2 lakhs does not arise here. It's only that there is a.
To me, it would not, but my learned friend would argue otherwise, because he would say conversion order says this order is subject to you acquiring other permissions under other legislations. For example, BWSSP deposit, property tax, amount, then the marketing and advance, administrative staff salary, loss of opportunity. Under all these heads, my learned friend has placed a claim, and that claim goes to beyond 40 lakhs. From 2 lakhs to beyond 40 lakhs. Conversion expenses for conversion is 1,26,514. Sanction for BWSSB deposit is about 5,26,650. Property tax, he says he has paid 29,806. Amount paid to respondents 15,10,000 he has included, but that if that goes, the amount will be different. And he has, your lordship also kindly recollects in clause 1, it says at his own expenses using his own personnel. But here he claims marketing and administrative salary of 8,79,000. Then loss of opportunity to the claimants 11 lakhs, that is indirect damages, 11,70,000. Amount paid and payable to architect 1,50,000. And miscellaneous expenses incurred 2,50,000. These are the various heads under which he has claimed before the learned arbitrator. In addition to this, damages for idle investment is about 21,51,000. That is interest at 18% on that amount of 15 lakhs, which my learned friend is pointing out. Then damages towards debt investment towards statutory payments. That is 7,21,000. Again, that is interest not on that BWSSB deposit. Deposit is BWSSB deposit is about 5,26,000. The interest runs into about 15,32,000. Then expenses incurred by way of salary paid to employees of the claimants towards liaisoning, work carried out for obtaining conversion, sanction, etc. from concerned authorities. He claims about 18 lakhs. All this included, only the interest portion is 54,88,000 at the time of claim itself. Then under paragraph 9 of the award, the 4 different heads are there. For a moment, if my lords would come to paragraph 9 of the award, it is at internal page 8 of the award. Page 54 of the memorandum of appeal, ink page 54, internal page 8 of the award. The lordships are at para 9, 4 different heads. Expenses incurred as stated earlier, 54,88,000. Damages payable for idle investment by way of payment to respondents of rupees 1,51,000. Getting idle, calculating it at 18% interest per annum. Kindly see item B. Out of it should have been 15,10,000, not 1,51,000. It is the typographical error on the left hand side. For that interest is 36,61,000. Then item C, damages payable for idle investment by way of expenses incurred amounting to 11,70,000 at 18% interest per annum from date of conversion, namely so and so, 24 lakhs. So these two items, not 36 lakhs and 24 lakhs odd, they are the interest parts. Then item D, loss of profit, rupees 60 lakhs. So this is again, this loss of profit is indirect damages, is what my learned friend is claiming. So section 73, 74 and 75 of the Contract Act also will have to be considered by my lords.
So the claim was
1 crore 75 lakhs 67,555. The learned arbitrator would allow some of these items, would and reject some of the items. The summary is at para 34. Uh, 34 onwards.
34. Yes.
Therefore, the claimants, instead of getting the amount of 54 lakhs 88,000 as claimed para 25, would be entitled to get the following amounts. Damages for idle investment 11,21,000. Then damages payable towards dead investment of statutory provisions 4,79,000. Expenses incurred by way of salary paid 4,18,000. Essentially, my lord, the claim of the claimant at the rate of interest at the rate of 18% has been cut down to 9% by the learned arbitrator, awarded in full. Then lord, para 35, no doubt the claimants have claimed rupees 1 crore 75 lakhs 67,000 as stated in para 27 of the claim statement. They will not be entitled to get so much of the amount. The expenses incurred at para 25 have been shown to be 54 lakh 88,000, but as observed above, it would be 32 lakhs 27,000.
55 lakhs 27,000.
What?
35 lakhs 27,000.
I'm sorry, 35 lakh 27,000. Damages payable for idle investment at para 27B is shown at rupees 36 lakh 61,750. The learned counsel appearing for the claimants has stated in the memo dated 7/4/2014 that it has been wrongly calculated by including the interest part, which has already been claimed at para 27A. Therefore, he has claimed only rupees 15 lakh 10,000 without interest. This said contention also is not correct for the reason that interest has been added as stated in para 32 above, and the principal amount has been included in the sum of rupees 35 lakh 27,000 as stated in para 27. The claimants have claimed the damages on rupees 11 lakh 70,000 at 18% per annum amounting to so and so. This claim of rupees so and so has been allowed as stated earlier, and interest at 9% works out to 526 for a period of 5 years. No doubt the claimants have claimed rupees 60 lakhs as loss of profit. The learned counsel appearing for the claimants contended that if this project has been completed, the claimant should have got profits. Therefore, they have claimed the said amount. It is to be seen that the claimants are still at initial stage of getting the possession of the land. It is only after possession is given, respondents are required to execute the joint development agreement. It is only after the execution of JDA, and if there is to be any breach, then they can claim the loss of profit. The claimants have not yet purchased the necessary infrastructure for putting up construction. No evidence has been laid in that regard. Profit could be claimed only if they are eligible to get the apartments constructed. The permission given for present and exhibit P1 are only to get the land converted from agriculture to non-agricultural purposes. Moreover, they will not be entitled to get any amount as claimed under the head of loss of profit in view of decision in so and so. It is not unusual for contractors to claim loss of profit arising out of diminution in turn over on account of delay in the matter of completion of the work. What we should establish in such a situation is that had he received the amount due under the contract, he could have utilized the same for purpose some other business in which he could have earned profit. Unless such a plea is raised and established, claim for loss of profits could not have been granted. In this case, no such matter is available. In the absence of any evidence, the arbitrator could not have awarded the same. This aspect was very well so and so. Therefore, we have hesitation in deleting a sum of rupees 6 lakhs awarded to the claimant. Hence, the claimant shall not be entitled to get an amount of rupees 60 lakhs towards loss of profit in the absence of such materials as stated therein. So, my lord, what is discussed here again, Lord, I am at loss of words for understanding, but nevertheless, what I gather here is the claim for sum of rupees 60 lakhs toward loss is rejected.
Now, what has been ordered is this 35,27,004 is the interest plus the 15 lakhs which has
Yes.
been
Yes,
given to you. Then idle investment, what has been ordered is only 5,26,500. Then
that is also interest only, my lord.
by way of idle investment by way of expenses incurred on so and so at 9, whatever. Amount eligible instead as stated in para 25 is 2018,995. The
Totally, my lord, 60 lakhs is awarded.
now what has happened?
That after,
Who
yes,
have settled for
18
21?
18 according to me, 21 according to my lord.
If it's 21 also, 42 lakhs has been
Is
paid
paid.
out of this amount.
Yes,
Is that right?
Yes, mother.
So what is payable is the balance amount with interest.
Balance amount with interest.
Would be what is payable? Interest from when?
Lord,
2014, my lord.
on a legal ground, my lord, I have also contended
Hmm.
that in terms of section 44, my lord, there is no apportionment done. So, my lord, it has to be equal.
Hmm.
So, my learned friend's contention that I am 17 guntas, the other two are, yes,
If there is no apportionment, we'll take it that it is equal.
Yes.
Because now two have also settled.
yes,
So the amount would be 60, 72,499 into 9% interest for 12 years. Correct?
What?
9% per annum for 12 years.
From
From
2014, my
2013,
lord.
9/12/2013 onwards,
Yes, my lord.
from the date of the claim petition, it is payable. Therefore, for 12 years, 9% interest.
Yes, my lord. Roughly, it comes up to 45 lakhs.
5,46,524 into 12. 65 lakhs 58,000. 98 plus 60, 72.
18 lakhs into 9%.
42 lakhs.
My lord.
42 lakhs is the amount paid.
But the date of the award is 10th April 2014, not 13,
Not 30.
2014.
No, not the date of the award. The order says claimants are entitled to get so and so together with current and future interest from date of claim petition. That is 9/12/2013 till date of payment at 9% per annum. Page 70.
But that was the claim, my lord.
That is the award,
Yes, my lord.
But award is,
if I am not mistaken.
Compounded interest has to be calculated.
of course, it will become interest on interest, but it has to be, your lordship could have to consider only from the date of the award, because that is not clear. Roughly, my lord, on a rough calculation,
Are you sure?
yes, my lord.
The award says from date of claim petition.
It is very clear, my lord. From
Yes,
9/12/2013 till date of payment.
My lord, between the date of, very well, my lord. Yes, I'm sorry. 9/12/2013, that is, my lord, so it has to be 11 and a half years, if at all.
Correct. 11 and a half. Not, it won't be full 12. And also it will go much beyond the entire amount award with interest. It will go beyond 80 lakhs. Nearly be something like 80 lakhs.
1863, my lord, I'm getting 1863 plus 18 lakhs. It's about 36 lakhs, 37 lakhs, my lord.
No, my lord. No, my lord. As
Lord.
on the date of
We have to
2011.
take whatever is the amount due
Very well,
and then deduct what has been paid.
very well.
Is that not the only way to go about it?
But 60 lakhs minus
lakhs.
42 lakhs is about 28 lakhs.
It's not how you go about it.
Lord,
60 lakhs with 9% interest
Exactly,
for
madam.
11 and a half years, minus 42 lakhs.
Absolutely.
But 60 lakhs?
With 9%
9%.
interest for 11 and a half years, minus 42 lakhs. Is the problem.
That could not be, Milord.
That is the
cannot
only
be.
way it can be done.
But then it is hit by the provisions of the Contract Act. He cannot behind my back settle at a different rate with others.
Absolutely no, Milord. I
In
never.
that case, there is,
Did you object?
it is not in the, it was not an
Absolutely
exchange
no.
of communication for the purpose of settlement.
No, Milord.
It was not an exchange of communication. It is not, even placed before any court, or tribunal.
Therefore, we are saying that it may be in your best interest to reach a settlement with regard to the amount.
Very well. I will.
We cannot now say that you need to pay only what the others paid. We
No,
are
I'm
unable
not,
to say
I'm
that.
not.
We cannot say that.
I cannot request my lords.
And we can also not say that it is from the amount found by the arbitrator that this 42 lakhs for which they have settled has to be deducted and then the amount has to carry.
Yes.
That is not how we can do it.
No, it's only a settlement proposal. It is all that is all. I cannot indulge my lords for that amounts, that quantum of figures. I can only point out to my lords.
You could point out that this would be the amount that to your client.
Yes.
That this would be the amount that would be payable if the Section 37 is not successful.
From that perspective, my lord, 20 lakhs from the date of award and 9% interest thereon is what my lords are indicating. Because there is no apportionment. Not, I could not be.
Because there is no apportionment,
Yes.
it would be whatever is the amount with interest minus what has been settled by the other. Tell us how else.
I will have to.
Milord.
Yes, you will
I will have to better the argument.
Absolutely.
Yes.
Because this is the only way we see it. So if as a matter of fact, that is how it is to be done. Otherwise, we'll hear you on if that
On
is
merit,
not
yes.
how it is to be done. Even on the calculation of the balance, we'll hear you
Right.
with no difficulty. But if as a matter of fact, that is how it is to be done, then you're looking at a much higher.
Much higher. But my understanding is slightly different, but I'll try to, my lord, better my argument on that.
Authorities.
I will.
Milord, in the meantime, anyway, the claim amount will be more. I may be permitted to withdraw the deposited amount, which is 30 lakhs, Milord.
It could be once for all disposed of, not.
Milord,
But then I lose
Milord,
whatever.
to be
this-
honest, Milord, 20 years I
Milord,
kept
I
my
have
money
said-
idle,
Milord, I
and
have
my
said-
clients are becoming age old.
We understand. The only thing is that if that is also there,
Yes.
it might be a reason for them to come forward and say.
That's all.
They have become senior citizens and they are in the verge of evening life. At least let them enjoy that money, at least now, Milord.
You've been senior citizens for more than that. Let's list it up.
Since 20 years, the case is going.
Yes.
Short,
There
right?
are also
Not 20.
carrying on either side.
In 2 weeks' time.
That an attempt can be made to see whether there is any chance of settlement in the matter. Just after 2 weeks, give a date immediately after 2 weeks.
No, kindly date may be fixed, Milord.
Exactly 2 weeks.
24th or 25th minutes. Great.
Much obliged.
Let him also, my lord, speak to his client and consider.
Definitely, Milord.
We continue tomorrow. As much as possible. The difficulty is that the date matters. You're aware every day there are dates.
My lord, may I be permitted to make a submission as far as 62 is concerned, my lord?
Yes, we'll see when it can be listed.
Not in terms of an adjournment, my lords. It's a request to call for the records of the Section 34 court.
Yes.
I'm grateful. I'm grateful.
Court officer, madam. Court officer, madam. Court officer, madam. Court officer, madam. Sir, idara court officer, madam.
Hello.
Madam, serial number 57, madam. How many weeks has it gone to, madam?
30th, sir.
30ನೇ ತಾರೀಖಾ?
30th of June.
30th of June. Thank you so
Yes.
much, madam.
Okay.
Thank you.